That was a half a second early. I actually think that was a half second early, if not utter perfection. And I said utter, not utter perfection. That's what you find on a dairy farm. Boom, ching. Good evening, everybody. Let us wait for the standard Fs. I'm not late. I am very, very rarely late. I have a pet peeve about being late, and I'm on time. And it's going to be, look, Robert gave me so much freaking homework. I have spent the better part of the day trying to be a present parent while reading off my iPhone and reading 50-page either lawsuits or decisions off an iPhone. It's not the easiest thing in the world, but I got her done. Get her done. Okay, we got a full menu tonight, and it's going to range from everything. You can all tell there's a COVID banner apparently on this stream. There will be no medical advice. There will be no contradicting established science. There will be no scientific advice or anything. We talk the law. But sometimes there's a crossover between the law, politics, and everything else in this world. We're going to be talking about some of these lawsuits. We're going to be talking about critical race theory lawsuits. I don't want to set this one up too much. The critical race theory lawsuit, I'm reading it and I feel like I'm losing my mind that this allegedly, what is being alleged in this lawsuit is actually happening in this world. And it doesn't shock people's consciences. It doesn't shock the conscience of everyone. And I'm convinced it would shock the conscience of 90% of the world, or 90% of America, if only 90% of America knew what is going on. And I include Canada in that because Canada's in North America. All right, let's see what we got here. The John Beck says, if you think Viva is late, watch Gary from Nerdrotic. I don't know about that, but no, I'm compulsively on time to the extent possible. All right, let's just get one more super chat before I get into my rant, disclaimers, live stream. In that order: rant, disclaimers, live stream. I loved your earlier post about Legal Eagle and Tim Pool's case. I hadn't thought about Legal Eagle since his TDS. I've got to share that on Twitter and tag Legal Eagle because it was kind of funny and good-natured humor, not any mean-spirited humor. Because even Legal Eagle has to own up to that Captain Marvel debacle of a legal breakdown where everything is self-defense. Viva, give me some hope for the future. Jessica Cora, when I start going hog wild on the PPC candidacy, there will be hope or there will not be hope. Actually, I guess I'm not giving you hope. I'm giving you uncertainty. Hope for the future is that on a Sunday night, we have close to 10,000 people who have taken a keen interest in learning about the law, which is nowhere I'd ever thought I'd be in my life. I remember in the early days of the vlog, someone said, Dave, you should do more of the law videos. And I said, it's tedious. I want to get away from law. This is my ikigai, which is bringing the law. First of all, I would be doing this on my own if, even if it weren't for YouTube, but bringing some interest and some insight and some sanity to the world of law. Okay, let's see. We got Thomas Caldwell, 7, Copenhagen, 10,000. Hey, I actually got the notification in the Arizona audit on for tonight. Yes, well, I got my own questions for Robert because I'm seeing Nate Brody tweet about it. I'm seeing Nick Rekieta talk about it. And I'm seeing some media cover it and some media not cover it. And I'm seeing some Twitter handles freaking out about it. So it's on. We're going to talk about the legal status of those audits, with no undermining or questioning the elections, because that's a no-no unless you're President Biden questioning the year 2000 elections. The best part of watching Viva is watching him slowly become more red-pilled on what's going on in the world. I have either put on those goggles or taken them off. I cannot see the world any differently than I see it now, and I will never be able to see it the way I saw it back. Let's just take 2001, for example. I will never be able to see the world the way I once saw it. It's a blessing and a curse, and it might account for some of the gray hairs that people were noticing from today's vlog. I know Barnes isn't a big fan, but can you try to get Ben Shapiro on? I think it'll be very interesting with the two perspectives that they have on law and current events. I think we could do it because in as much as Barnes is hard on Ben Shapiro, Ben's got to be used to it, and he dishes it out. So if Ben cannot deal with Barnes's critique and jabbing and needling, then Ben has no business dishing it out on others. So there's that. Okay, standard disclaimers. No legal advice. No legal advice. This is for educational purposes only and possible entertainment, but mostly education, but no specific legal advice. Super chats, YouTube takes 30% if that bothers you, and I know it bothers some. If you want to support us, you can support us on Locals. You can support me on Patreon and Subscribestar, but don't waste your time there. Locals is where the party is at. Tons of exclusive content. Art of the day. I've got the Tuesday, Thursday, Saturday shift. Robert's got the other day's shift. Exclusive content, exclusive live streams on Locals. Thus far, it's only one of us at a time, but it's a great place. For support, all of the content is going to be on YouTube and Rumble. We are simultaneously streaming on Rumble. Everybody should know that. So that's that. Super chat, I'll do my best to get to them. If I don't get to them and you'll be miffed, do not give the super chat. I don't like people feeling miffed, feeling rooked, feeling, what's the word? Shilled. Or no, what's the word? Grifted is the word I'm looking for. I don't like people feeling grifted because I am not a grifter. I love the support. I appreciate it, but it's all voluntary. If I don't get your super chat, don't be miffed. If you will be, don't give it. Okay. With that said, Arizona audit is being done freaking perfectly. Just look at how the ballots, they just looking at the ballots, not looking at who voted for whom. We're going to get there. We're going to get there. Please check out the Civil Rights Lawyer on YouTube. He's doing great work. I do not attest or deny this. I am reading it. Civil Rights Lawyer on YouTube. Longtime support of Locals. Thank you guys. Wait, we got new member. Oh no, I brought that up before. Okay. Let me start with a little bit of a rant from our dear Minister of Heritage, Guilbeault. What's his name? What's his first name? Oh, tabarnouche. What's Guilbeault's? Anybody who knows in the chat? Michel Guilbeault? It's Stephen Guilbeault. Stephen Guilbeault, our Minister of Heritage, is now on a kick about how, in order to preserve democracy, you have to censor online discourse. Censor for hate speech. And I'm saying hate speech not because I tolerate or approve of hate speech. To illustrate that the concept of hate speech has become so vague and nebulous that if we're going to apply the level of hate speech that I know Michel Guilbeault wants to impose, we're going to have comedians like Mike Ward censored off YouTube because some of their humor is deemed to be hate speech. You're not going to foment any discourse by censoring hate speech. What you are going to do is stifle political opposition who you have branded as hate speech, extremism. If you speak out against wearing a face mask, you're a selfish extreme right-winger, unless you're Jagmeet Singh, the leader of the NDP, who's doing it on his own because he had a moment of weakness. And I feel like I'm going to fly away like Chris Farley in that skit. There is a concerted effort from the Liberal government in Canada, in conjunction with the NDP, with opposition. Let me get another one of these butterflies. Opposition from the Conservatives. With opposition like that, who needs opposition? That's as good as support. My brother's a major supporter of the PPC, People's Party of Canada. He asked Bernier about American-style rights for Canadians and was buffed off. There is far too much cowardice in politics. We must have human rights in Canada. Oh, we have human rights with a but. And it's a big but. And it's not the kind of big buts that people like. It is, you have rights, but you have the notwithstanding clause in the Constitution, basically saying we can enact laws that violate your constitutional rights if we specifically provide in that law that we're violating your constitutional rights. And then it's only good for 5 years, or for maximum 5 years, or as long as that government decreed it, less than 5 years. The theory being, if you don't like having your constitutional rights violated by the government, vote them out the next election, which typically comes every 5 years. We have a notwithstanding clause in our Constitution. You have constitutional rights, but we can take them away if we specifically provide for it in a law. Certain constitutional rights cannot be taken away, like the right to vote. But it seems that anybody's rights, for anybody who's been following, we have no rights. They can be taken away overnight by mere health measures acts without going through the legislative process. And hey, if people think that it's for their own good, some of them don't bat an eye. All right, there was that. So that's where things are at in Canada. And we're going to have a fun discussion when the election is called and I am formally a PPC candidate. I've created a second channel. I'm not turning this one into politics, but it's going to be a fun discussion. Now, with that said, it was a great sidebar with Jones. It was great. And I say it was great. Someone told me I was, they saw Alex Jones responding, like, was surprised by some of the questions I was asking because they were not what's the word I'm looking for? Confrontational, but they were more direct. I don't know if that person was projecting, but I genuinely think that I understand Alex Jones better and as a human now. And it's going to be up to the world as to whether or not anyone can ever be forgiven for certain wrongs that they've ever committed, and to what they have to do in order to repent and obtain forgiveness if they ever get it. But I don't think anybody who watched that does not think that they understand Alex Jones better now, for good or for bad. I think the biggest problem is the powers that be just don't want people understanding the likes of Alex Jones and others, which is why they deplatform them, in order to demonize them, in order to control the discussion around them, so that good, educated people hate someone and they don't even know why they hate them. From Alex Jones to Robert F. Kennedy, and that's coming up tonight in the discussion. With that said, I see Robert is in the house, looking good, dapper. And Robert, how's everything going?
Good.
Okay, so we've got. You gave me so much homework. I got through a lot of it. Some of it I didn't get through, but my goodness, some of it I'm sitting there reading, and I don't believe what I'm reading. It's like being in a Kafka novel, or I don't know, worse. But I guess I set out something of a what's the word? An outline for the evening, and I figure we should just start with the most pressing one that I know everybody's talking about. Jen, and I'm going to say Psaki. It's Psaki for the rest of my life on the internet. It's Jen Psaki. Apparently, it's a silent P, but I like Psaki better. So Jen Psaki's press conference, and some of the, I'm calling them admissions because there's no way to downplay the degree. Some are going to call it cooperation, collaboration. I'm going to go one step further, and I'm going to say control or coercion, or coercion or control, because it sounds like they are effectively imposing control over certain aspects of Facebook. I did a vlog on it. Everybody saw what Psaki said. They are working with Facebook, doctors, federal officials, meeting with them, discussing what information to promote, trusted news sources to promote, flagging posts for Facebook, not on Facebook. And some people think that's semantics. I think that is an admission of the level of control that they are exercising over Facebook. The question now becomes, are these admissions enough to become, to cause Facebook, at least in certain circumstances, to be deemed to be state actors? Yes or no? And then we're going to get into the other criteria that might flow from this.
Not by itself, no. I mean, it's helpful evidence. It doesn't hurt, that's for sure, because as you highlighted, her use of the word for, rather than the other word term she could have chosen. And they're kind of bragging about it. They're kind of open and public about it. So I think that helps anyone bringing litigation related to it, including, not only of Trump's case, but obviously Bobby Kennedy's case that's going up on appeal, and Harmeet Dillon's case, which is still the strongest in California against Twitter. So, I mean, to be a state actor, a full state actor under our current case law, they make it really hard. You basically you have to look at agency law. And are they acting as an agent of the state? And if they're not acting as an agent of the state, under, like, if this was, say, Facebook, say John Johnson said that he wanted Facebook to do something, would that constitute, does that make Facebook, if they later do it, an agent of John Johnson? Generally, under agency law, it does not. There needs to be more than that. And so it's helpful evidence for those people bringing it, but to really bring a robust state actor challenge, what you need to allege is that they did it at the direction, at the behest and behalf of that group, or that they're occupying a traditional public field, but that's really an alternative argument. That's the Prunier doctrine I've talked about, that requires challenging existing federal law. State law in California supports it, but the courts have been very reluctant to apply it to big tech. So the short, it helps, but it's not determinative.
And now, so this is in the minimal amount that I've looked into U.S. case law, I saw that it's virtually not impossible, but the bar has been set extremely high for state actors. It's a public function test in that Edmondson Lugar lawsuit, where they have to be exercising what is typically a role reserved exclusively for the government. So one case was a private election where they were deemed to be state actors, but utilities, no. So providing utilities to people was not deemed to be a state actor, where cutting it off could violate constitutional rights. The bar is high, but there's a state actor argument on the one hand. Am I wrong? The other arguments, entanglement, coercion, are those different facets of the state actor argument, or are those separate legal criteria whereby a private actor can be deemed to be a state actor for the purposes of specific conduct?
There's multiple means by which they can be considered a state actor, or another way of thinking of it, simply subject to the Constitution's restrictions. Because, for example, in Marsh v. Alabama, which is the predecessor to the Pruneyard Doctrine, there was no dispute that those were private actors who were not acting at the behest of the state. So they weren't state actors in a literal sense, but they were considered bound by the First Amendment anyway because they were occupying a public function. Same with the Democratic Party cases. Originally, the Democratic Party got away with racial discrimination and other forms of discrimination because they said they were a private party. They were not a public state actor, though they determined who got on the ballot and who didn't. And finally, it took the court a while, but it was many decades the court bought that doctrine, or different courts did, and until the courts came back and said, no, okay, you know what, this is an election and you're performing a public function. So different aspects of entanglement, different aspects of collusion can constitute, the way I would put it is, can have the Constitution apply to that private actor's conduct. They may not literally fit the definition of a state actor, but that's irrelevant for the legal purposes that's trying to be sought after.
Okay, and so I said it in the pinned comment of the video, but does Trump amend? Well, first of all, can Trump amend his claim? And if he can, does he amend it to include this, or is it irrelevant for the purposes of that lawsuit?
Well, I'll be on
with the Facebook one, not the Twitter one.
I'll be on with Dave Rubin this week, discussing precisely that. He absolutely has to amend that complaint if it's to have any chance whatsoever. And this fact would be a helpful fact, but what he really needs to allege, he can use this as ancillary evidence, collateral evidence, corroborative evidence of changing the allegations to specifically allege that Biden and Harris and Pelosi and Fauci ordered his removal from these platforms. And this is just additional evidence that corroborates his inference of that conclusion, for which he needs discovery ultimately to document.
And I just brought up the chat. Does this admission, does it lend to succeeding beyond a motion to dismiss for the purposes of discovery to see the extent of this entanglement, coercion between the government, the feds, and Facebook?
Only if he alleges more than he's alleged so far. And even this wouldn't be enough. He needs to specifically allege that those individuals ordered the big tech platforms to remove him, and that they did so in response to those orders. Anything less will be inadequate to get past the motion to dismiss at this stage.
All right. And now, actually, I took notes tonight, people. This is how much, Robert, there we go. Look at my handwriting if anybody wants to assess my mental state. Nate, the lawyer, incidentally, who's going to be front page New York Times tomorrow in an article that everybody should read. The front page of New York Times is easier to read than the digital version, which is behind a paywall. He was having an online Twitter argument with Rekieta, and Rekieta raised an argument which I'm not sure that I understand, but the chilling effect on First Amendment that what the government is doing right now with Facebook is having, such that it opens the door for some form of argument before the courts, but I'm not sure I understood the argument.
The idea is that if the state takes such action that a private actor feels obligated to follow whatever the state is instructing it to do, then that can convert them into a state actor. Now, normally that's been very, different circumstances than present here. But in this context, the best statement would be the combination of the press secretary's statement with Biden's later statement, basically accusing Facebook of murder for not going along with his directions. So that, here you have the chief law enforcement officer of the land accusing you of murder unless you do what he tells you to do. That might be what Nick Rekieta is talking about when he talks about there's some case law out there that says if the government takes such action that it's a chilling effect, that it's basically dictating in direction, and that if you don't take that direction, the state will take adverse hostile action towards you, then that can convert a private actor into acting at the behest and behalf of the state. But it needs to be specific. So, like, for example, just because Facebook is being a state actor in one setting doesn't make it a state actor in every setting. That's where someone like Trump needs to specifically allege that as to him, they were acting at the direction of these individuals. And what they said this past week enhanced his potential claim, but and he's also got to just shift up the claims. Some are state actor claims. There's different theories of state actor claims. There's different theories by which they can be bound by the First Amendment that are technically separate from the state actor claims and other common law claims he needs to add, or that suit is dead on arrival.
Interesting comment by William Skrainsky, who will never get past this avatar. What's the difference? Biden will evoke executive privilege in discovery. Fair point.
Actually, I was going to say it's actually harder than that. If Biden won't be a party to the case, so that means you have to get through this whole other doctrine where it's very tough to subpoena the government for it when the government is not a party in the case. So they call it TUOHY principles, TUOHY. I've won several of those, but they're really, really hard. So you have to get through those before you even get close to executive privilege. So normally they don't allow you to subpoena the president unless the president's a party to the proceedings.
That is, and now can the government object? Hypothetically, they get past a motion to dismiss. There's discovery. Can the government object to Facebook or Twitter, whichever one it might be, communicating documents that include the government?
No. I mean, anything that's in Facebook's custody is not subject to governmental privilege of any kind.
Okay. Oh, and by the way, let me just bring out the beard power. I may trim the sides, people. I may trim the sides. I put up a question on Twitter. It's getting there, but man, I feel like that Kids in the Hall, for anybody who doesn't remember that particular skit where one of the kids in the hall grows a vacation beard and then he never wants to shave it. That's how this thing gives me power, it feels like. Okay, so we'll see where it goes. It's not as big of an admission as some might hope, but it's certainly, if nothing else, should be terrifying for everybody. What we see going on between big government and big tech.
Oh, no doubt. It's, I mean, you saw Glenn Greenwald. It definitely caused a lot of controversy in the court of public opinion. And so it was an interesting admission. I mean, it seemed to be bragging about what they were doing. And it does give, again, corroborative evidence to make the direct allegation. And then that's what people need to make the direct allegation. They need to say, upon information and belief, the government ordered my comment removed or me removed. That's what they need to allege to fit the state actor doctrine. And all of this evidence is strong if they say, well, did you have a factual good faith basis for it? Like the various election sanctions hearings that are taking place with Lynn Wood and Sidney Powell and others. That's where you can say, well, look at all of these statements, including from the President of the United States, the Vice President of the United States, the Press Secretary of the United States. So, they did give a big boost to those potential cases by being so open and arrogant about it. But it shows their commitment to it, in my view, that they're going to do it, they're going to brag about it, and they expect the courts to stand by and say nothing.
Because I still think it's a massive admission, because it's not just that she said for instead of on. It was in the context of the degree and detail that she was going into, Jen Psaki, about the active efforts and the active, some will call it collaboration, but like when your boss comes into your room or your office and starts like collaborating with you, it's more like under their direction. Now, some people are going to argue that Facebook is bigger than the government. Bottom line, the government's pretty darn big. And when they come in and say, look, we're going to work with you and we're going to help you tag misinformation, promote good information, and we're going to flag posts for you. That, to me, in the context in which it was spoken, sounds like the government has effectively come in and nationalized, at the very least, Facebook for this particular behavior, which is information relating to COVID. Whether or not it turns them into imposes constitutional requirements on them for other stuff like taking down certain pages, whatever, separate argument. At the very least, it seems to have opened the door for that. But the degree of the collaboration that Jen was describing went well beyond just the use of the word for instead of on, in my humble opinion. Oh, yeah. But on the subject of criminalizing potential misinformation, explain to the world what measures are being taken in the United States right now to potentially criminalize misinformation on certain issues, specifically COVID. And then I want to circle back to Joe Biden's statement after that.
Yeah, so I mean, it's really kind of frightening. There's two ways to read the criminal complaint. A criminal complaint was brought against I would call alternative health provider, not a medical doctor. They have a different title for it in California, but for these various sort of alternative health providers, someone who's providing what they claimed was a vaccine for COVID that's not a government-approved vaccine for COVID. That basically were these pellets that had little bits of the virus in it to give the person immunology, according to them. And then they were giving them COVID vaccine identity cards as part of that. And there's a specific allegation that some of the vaccine identity cards purportedly claimed to be a Moderna vaccine when it wasn't. But you dig into the federal criminal complaint. They're now trying to criminally prosecute and punish this person. Part, they're claiming it's wire fraud. And I was curious, okay, what exactly is the fraud here? And are they limiting themselves to just saying that, well, if they'd given them a vaccine identity card that didn't have Moderna on it, then we would not call it fraud. But that's not what they're saying. What they're claiming is an extraordinary federal criminal authority that any person that makes a statement concerning healthcare can now be criminally prosecuted if the FDA or the federal government or other state government officials disagree with that person's opinions about healthcare. And that is frightening. So these criminal statutes, the wire fraud statute is supposed to get to actual fraudsters, people who defraud other people of money. There's not clear evidence that anybody here says that they were defrauded. So there's that issue. It's kind of like a build a wall kind of issue. Then the second component is the corollary component is that any statement is they're taking a healthcare fraud statute that was designed originally to deal with Medicare and Medicaid fraud principally, secondarily state unemployment, workers' comp, things like that. And this is a dramatic expansion of that statute. And it was traditionally thought that this only applied to, like, for example, here, there's no allegation of an actual healthcare plan. There was no healthcare plan involved. So I get that they've expanded. They started out with the federal health programs, then expanded into state health programs, but now they're going, and then they had expanded to private healthcare plans. There was always some controversy about that, but now they're applying it. And then they said, well, we'll only apply it to healthcare providers. Now they're applying it to someone who's not a licensed doctor, medical doctor, number one. And number two, it doesn't appear to relate to any healthcare plan of any kind.
But Robert, I mean, the obvious question is going to be, what would be otherwise the normal recourse for that type? Let's just call it fraud. I mean, let's say someone's selling you snake oil, saying that it cures COVID. There has to be some remedy. There has to be some prosecution of that. What would be the normal way of going about that in the absence of a politicized system? Like, how would one go after that type of misrepresentation fraud?
There's two different things with it. One is whether or not it's a federal crime. Second is whether or not it could be a state crime. And separate is whether it should be a crime at all, given the usurpation of authority that comes with criminalizing things. My own view is that should be a civil tort claim. If you think somebody sold you something false or fake that wasn't what you paid for, then you should have a right to sue them and get remedy. I prefer the civil tort system that leaves the control and the power, because this is always about who has the power. It's what the law really is. Who gets to decide. I would rather the individual that feels harmed have the power, bring the claim, and then a jury to make a determination. When we let the government make those determinations, they inescapably and inevitably will criminalize things they simply don't like and don't agree with that go beyond what, like here, you have no one who's sued. No one is suing the person. It's not clear that any one of the customers has a problem or believes they were defrauded. It appears they got exactly what they paid for. So it's like, who exactly was harmed here? So it's the state, in this case, the federal government, saying that, I mean, there's always a problem to say healthcare somehow is subject to federal jurisdiction anywhere, any place, anytime. It's not clear that anything ever crossed state lines, for example. That it appears to be local people decided they wanted an alternative for COVID, wanted an identity card, and apparently this person provided other immunities for other things, so their kid could go to public school in California where you're required to have immunity cards. So it appears that that's really what's going on. That strikes me as a local issue. I think it should be a plaintiff issue. But imagine if you read the whole federal complaint by the FBI, they're basically, like, for example, they're saying it's criminal fraud if anyone anywhere in the country in a quote healthcare context says that the COVID vaccine is not safe and effective. I mean, that's what's in the affidavit. That's one of the allegations of criminal fraud. It's like, hold on a second. This is supposed to be limited to when you say you did a service and you didn't do it and you steal from the health insurance plan. It's never thought that it would apply like this. And if this case goes through, and not surprisingly, they brought it to Northern District of California, where they have the most pro-government judges on these kind of issues, it's terrifying where it can go.
This is the problem, because look, maybe I'm speaking for people who don't share this view. I think there is something fundamentally problematic and I would say almost dangerous to say, look, I'm giving you a pellet, which is going to give you immunity from a virus, any virus, so that people might act thinking they have immunity, natural immunity, which they don't. The fraudulent certification card's a separate issue. You take a bad case like this where most people are going to say, yes, something's fishy seems to be going on. You prosecute that case, but in the process of prosecuting that case, you broaden the otherwise what is going to be the tangential effect of that prosecution by, in that prosecution, including allegations that are broader beyond that particular context, so that you take this bad case and afterwards you say, look, from this bad case, or you wouldn't say the bad case, but from this case, it contained allegations that in the context, in the pattern of selling something which might not do what it does, with fake certifications and saying that the vaccine isn't safe or effective, you then use that bad case for broader purposes. That I understand. But I guess the question is going to be, yes, some people are going to say free market, let them sue for civil torts. But if you have somebody promising medical success on something that they're not a doctor and they have no reason to say what they're saying, or they have no proof, and they're selling falsified or fake certification at the same time, surely there has to be something criminal in there, at the very least, to set an example or deter others from engaging in similar behavior, if nothing else than impersonating a doctor or providing medical advice without a license. I mean,
if they had limited their claim to that, it would be a different matter. But they didn't limit their claim to that. And now the other thing that's important here is what the criminal complaint is trying to hide is that in all likelihood, every single one of these customers knew this person was not a medical doctor. They were seeking out alternative health, and what they wanted was this alternative health treatment. And so that they're trying to attribute to the defendant beliefs that most likely that the customers already had. And that's probably why there won't be very many customers testifying against the person, except under threat that they have a fraudulent document in their possession. And it's an interesting, other than the Moderna label, let's say that some of these immunity cards didn't have any Moderna reference in them, or the allegation is false about that. Then it's a question of, then it's really disputing an opinion. You have someone who believes that this particular method provides immunity, and we're now going to criminalize disagreement about that. I mean, that strikes me like they tried to say that this was a government form, and that's their allegation, is that but that itself was not very clear, because this person wasn't part of the government program they were referencing. So
yeah, or I would imagine if they do the exact same conduct with a big fat asterisk that says not FDA approved, not officially certified, not medically confirmed to do anything, just like homeopathic stuff, what is it called, echinacea, or anything else. Okay, yeah, it's non-FDA approved. Nobody's making any medical assurances. It's just that I see what you're saying, is that they take a case which is on its face bad, and then they use that to expand the scope of what they're going to ultimately argue are their powers hitherto for. And they've leveraged it off a case which on its face looks bad, but is going to be much worse if they succeed in doing what they're doing. And yeah, that's just the FBI, I guess, the government doing its thing, is take a case that may have some legitimacy to the prosecution, expand your powers, and then pivot, leverage from that on a going forward basis to go well beyond the scope of that original bad case.
And in my view, it's a big First Amendment case, because this seems like criminalizing speech. The commercial fraud has been a false statement of fact for the purposes of obtaining money. They seem to be wanting to expand this law to not cover that, to go beyond that, to basically say, like, for example, they said that one of the the allegations of fraud is that this individual advised people they believed the existing COVID vaccine had some toxicity potential in it. They're saying that was a statement of fraud that's now criminally punishable. Well, there's a wide range of people who have concerns about this, about the particular vaccine that we currently have. And what they're basically saying is that any one of you can go to prison and be charged tomorrow, because they don't limit it in the nature of that affidavit. That's why they were always going to take a case with the least politically protected individual, someone who made some mistakes that can be highlighted in a jurisdiction that's going to be hostile and inhospitable to them. But they've been trying to criminalize alternative health forever. And they're using COVID as the pretext to do so. But this is the most dangerous expansion of that criminal authority, especially on the federal side, that I have ever witnessed or seen. and it's a case to follow and track because they're not going to stop there. If they prevail, then and they have someone who doesn't like. You know how much so-called fraud was alleged? About $7,000. $7,000.
Well, I'm bringing up Truman. I don't know if he's mad at me or if it's a he. Yes, Viva. Tell us how the initial application is not the problem, just potential future uses. Defend the non-politicized FBI. Well, here's the deal. The politics ruins everything, and we've seen how it ruins the prosecutorial process. But it's not an accident that the FBI is going to take a case which on its face is going to garner a lot of sympathy from the general public. Yeah, somebody's selling a pellet that they are purporting gives immunity to COVID, along with a fake certification, and then we're going to throw in some other stuff so that we can expand our powers in the process. It's bad on both sides, and Lord knows the FBI and the federal government is looking for any excuse to expand its powers. And what better way to do it than to take a case which on its face it looks unfavorable to the defendants and expand your powers there? That's how politicizing the system goes. It's bad on both sides. But I still think, Robert, I respect the idea.
Wire fraud case ever brought. $7,400, and they're not even alleging all of that is fraud. It may be that $23 is the total fraud. We have the federal government, the FBI, spending tons of time to prosecute someone over maybe $20. I mean, potentially that may be the total amount of actual fraud that occurred because nobody else has a problem with it. Everyone else was someone who, I want this alternative treatment and I want an ID card and I don't want that ID card. They got exactly what they paid for. It's striking. It's not only an extraordinary waste of time, but it's a dangerous. Clearly the purpose is not this individual. The purpose is to expand its power to criminalize disagreement with the government. In the same way that you have Biden accusing Facebook of committing murder, being complicit in murder, the chief law enforcement for simply allowing different opinions about a vaccine to be discussed on social media.
Well, now I absolutely agree with you on the tangential expansion of powers that we're seeing, that we may or very likely are seeing from this. We're seeing it in Canada. We had a judge, I mentioned it, a British Columbia judge say, if you throw an underground party and someone goes to that party, comes back and gets granny sick and she dies, as far as I'm concerned, you're guilty of manslaughter. I mean, that is a criminalizing of behavior, an expansion of the powers of the state beyond, I would say beyond logic. But, and we're seeing it here. And I totally understand what you're saying is that the FBI throws in a few allegations here and there in an otherwise sympathetic complaint on its merits, set aside the amounts, the money's not the issue, Robert. It's that this one person can think they have immunity from these pellets, go to a conference.
Now, by the way, what she's talking about is a traditional way. I'll put it this way. Here was likely her defense. Her defense will likely be, even experts would likely opine that what she was doing was giving people small amounts of the COVID, and that they will likely opine that historically, going back to George Washington and smallpox at the time of the Constitution's founding, that is still even considered within some parts of the community a medical basis by which you can get immunity, is if you get the virus, but not so much of it that it causes great harm, but enough of it that you get immunity. She'll likely have testimony that will attest to that. So even that aspect is not indisputably fraud at the trial. She likely will have a defense that it's not like she was giving them something that was empty pellets that had nothing in it, for example. That would be your true, pure fraud.
Yeah, or something even worse, something that will make them sick, that purporting it'll make you healthy. And incidentally, it's very funny because I was just looking into the history of the smallpox vaccine today, and it goes back, back to the 1700s, but that's effectively back in the 1700s, how people went about it. Then we get into the era of modern science. I don't know if modern science has always been so politicized or political, but I'm seeing the way it is now, and it's not looking good. Robert, is this a good segue? Criminalizing misinformation might be the good segue into the big tech censorship and immunity and the lawsuit. Let me just go to my notes. The lawsuit that is being brought against Vimeo by a church not-for-profit and an individual who has seen all of his content on Vimeo taken down because 5 videos dealt with something. I had to write this down. I've never heard of it. Sexual orientation change efforts. SOCE in the lawsuit. And a brief overview of the lawsuit is the individual's name is Doman, Church United, suing Vimeo because Doman apparently was or I don't know how you qualify it, was homosexual, believes that he has become heterosexual, leads this or is a member of this not-for-profit church, has been putting up content on Vimeo, and they put up 90 well-produced videos, apparently, 5 of which dealt with sexual orientation change efforts, his journey as an individual. Vimeo not only took down the 5 videos, took down all 89 other videos and banned this not-for-profit from the platform. They sued Vimeo, obviously invoked Section 230 immunity. Did they invoke it? They invoked Section 230 immunity. And the argument was made as to why they should not benefit from 230 immunity. And they raise a good argument. It's one we've touched on, but I don't think we've actually ever gone into the full nuance between Section 230 C1 and Section 230 C2. I forget exactly what it is, but there's 2 provisions in the immunity provisions, what we typically regard as refer to as immunity. One is immunity for third-party content, and the other is immunity for their own actions in removing content. The former is what, as alleged in this argument brief, absolute immunity. Absolute immunity for third-party content if they have a certain system in place to try to remove it, but they leave some up. Their own removing of content has to be based in good faith. And this is where the lawsuit alleges that Vimeo's conduct is not in good faith, and it discriminates based on sexual orientation and other protected aspects. I think that's a fair assessment of a fair summary of the suit. If I missed anything, let me know. What's the status of this, and what are your thoughts on where it goes from here?
So the big news this week was, they had originally filed in California. The case got moved to the Southern District of New York, where the Southern District of New York dismissed applying both Section 230 immunity grounds. And what was unique here is the intersection, because you have laws on the books that say you cannot discriminate based on sexual orientation. You cannot discriminate based on religion. And here, the question is does Section 230 even give immunity for discrimination based on religion, or discrimination based on gender, or discrimination based on race, or discrimination based on sexual orientation? And the district court said, Section 230 trumps everything. You now have immunity. You can be bigoted. If you're big tech, you can discriminate against anybody, anywhere, any place, anytime for the worst possible reasons. So that was the first big thing, was how does Section 230 intersect with these other anti-discrimination laws? The second component was the bifurcated aspect of Section 230, as you note, which is one was about third-party content. The other was about its own content, or its own decisions, not third-party content, but regulating any content on its platform. And of note, originally the statute talked about all the things that are outside of First Amendment protection. So it was talking about obscenity, it was talking about those kind of things, and then it uses a comma and uses a phrase that I interpret to mean "and like things." Instead, it's so big tech, and a lot of the courts have been very accommodating, have just dramatically expanded that to mean anything big tech feels is disagreeable. This was one of the points that Thomas made. He's like, Section 230 never should have been interpreted this way, because it's not being read in the words it was written in. But they lost the Southern District of New York, went up to the Second Circuit Court of Appeals, initially lost, filed a petition for rehearing with the same panel, and that is almost never granted, but it was granted this week. So, and I think it was because this is where the comments of the press secretary, the comments of the president, these activities in other settings, Trump bringing suit, even if it's not a great suit legally right now, good for the court of public opinion, because it's more and more courts saying, okay, and Thomas issuing his multiple dissents on this subject, dissents to the granule of cert. So it's not like the rest of the judge court went against him. It was just him saying, here's the roadmap. This needs to be reexamined. It tends to come back. It's a confluence of effects back onto courts. And now you have a court doing something they almost never do, which is, hold on a second, maybe we made a mistake. Did we really mean Section 230 is this broad? Did we apply the right sections? I mean, why did we apply a section that only deals with third-party content to a legal claim that has nothing to do with third-party content? Maybe that's a mistake of the judges. But it shows you how reflexively pro-big tech all the federal courts have been, and most state courts have been too. There's like, oh, it's big tech, must be Section 230. They don't do a meaningful analysis anymore. They've gone far away from it. It's like when we were talking about the case earlier about criminalizing COVID information. This is how the government and big corporations win. They create a case that has bad facts, that creates bad law, that bad law becomes so enshrined over time that everybody in the court system just assumes it to be the correct law, never really doing any meaningful underlying analysis of the policies involved. So it's a big case because of what does Section 230 really mean, and how does it interrelate to anti-discrimination statutes? And
I was going to say, I mean, you already said it, but this seems to flesh out Thomas's roadmap in his dissent almost by structure of the lawsuit itself. It goes through the history of Section 230 as Thomas laid it out. It then distinguishes between the absolute, what has been regarded as absolute immunity for third-party content versus, not qualified immunity, but rather good faith conduct by the platform.
That's kind of the
itself.
definition of qualified immunity, is right phraseology. It's the most analogous.
And it is so. I mean, I said on the one hand, they read that decision and they laid out Thomas's roadmap in the pleading, and they might have been listening to us. There's a few cases tonight we're going to talk about where I think if people are not listening to you, Robert, and I say listening to us, but listening to you, it certainly sounds like they are. First question, actually, why did it get changed from California to New York, and then how does the New York court interpret the California law, because the Unruh Act is still going to apply or still at issue in this case?
Yeah, potentially, because of so it's just terms of service, venue provisions. So all these big tech companies in their terms of service require you, as a condition of using their service, to agree to any dispute being resolved in a particular place. Sometimes it's arbitration, sometimes it's a state court, sometimes it's a federal court, but also imposing a venue provision on it. I mean, I've represented, I can't complain about it too much because some of my corporate clients, I do this, I pick a venue that is going to be undesirable for the plaintiff trolls to be able to get to. Or if they do get to, they're not going to like it when they're there. So but that's what almost all of for most big tech, it's Northern District of California terms of service. This is a problem that Trump has on some of the defendants in the case he's brought in the Southern District of Florida. In this particular case, Vimeo has a terms of service that requires any legal action against them related to their service be brought in the Southern District of New York. And that's why it got transferred.
And SDNY, I guess we've talked about it, but so now it's going to be reheard by a panel of how many judges? 3 or the full panel? What would be a full panel? 9 or 11?
I think what I saw was just the original 3 at this stage. It said petition for rehearing was granted, but it only listed the 3 judges. So that were on the original panel. So I presume it's the same panel, and that's even more rare than a petition for rehearing en banc. Or I think that's, how do you say it in French?
I say en banc with a silent C, but I guess at some point
you're probably right. Here in the States, always say, en banc. It's like Lafayette. It's not Lafayette in Georgia. It's Lafayette. But it doesn't look to me like. But it's even more rare for a panel to say, you know what, we just screwed up in that opinion we just issued. They never do that. It's like a 1 in a million long shot. So for them to grant it means, this is why I always say the court of public opinion matters. No matter what happens in the court of law, keep hammering away in the court of public opinion, because judges are listening as much as anybody else. And this case is testament to it.
Geez, I'll share the link. I just have to remember to do it. It's a great read. It's extremely well drafted, extremely well motivated, and compelling. But I'm on that side already, so they don't need to work hard on me, but they got to work hard to get the same judges who just said no to say yes this time around.
Yes.
Nothing more on that case, eh?
Nope. I think that covers it.
Now, speaking of someone who I think has been listening to you, Robert, the Indiana University lawsuit. It's Klassen versus Indiana U. And they are challenging what they're calling the COVID mandate or the COVID restrictions of this university. I took a screenshot because I'll read it out loud. The requirements of this university in order to go back to university. I'm just going to read this here. It is Klassen versus Indiana University. Students have challenged all parts of Indiana University's mandate. Indiana University's mandate is multifaceted. It requires inter alia that all students, faculty, and staff, 1, receive one of the available COVID vaccines, 2, require their vaccination status, or 3, obtain an exemption, and 4, comply with the extra requirements if such exemption is granted, or 5, be virtually expelled. These extra requirements include, inter alia, participating in twice-a-week COVID testing and mandatory face masks in public spaces. Okay, so these are what students are being forced to face. Going back to university at Indiana University, they filed suit. I mean, basically, that's the essence of the suit, but elaborate and let the people know in greater detail what they need to know about this lawsuit, the status of it, and where it's going.
So they just had the oral argument last week. Judge said he'll be issuing a ruling forthwith on whether or not this mandate is constitutional, because this is a state university, so they're subject to constitutional limitations, unlike private universities in many contexts. So Notre Dame has also issued a equally harsh rule and restriction, and it too, of course, is in the state of Indiana. But this decision will have broad impact because at the front of the line of the COVID vaccine mandates are a bunch of public universities and private universities. And so where this case goes will have a lot of bearing on those future cases against those other universities and whether those universities stick with their existing protocols and policies. And it goes to the core of, whether or not they can mandate this, because some universities and states have been smart, and employers, they've said, we're not going to mandate this until it is an FDA approved vaccine. At this stage, this is an emergency use authorized vaccine. And so he brought the claims that are pretty analogous to the claims that we've been talking about and that I've articulated at vivabarneslaw.locals.com. I have a whole closing argument against COVID vaccine mandates, coerced COVID vaccines, as I call them. And we'll be talking to Bobby Kennedy this week because we figured we'd go with people that are low profile and low controversial. Last week we very low profile, low controversial guy, and this week definitely low profile, low controversial guy.
Now I'm going to just let out one thing, because I'm not saying it to needle the beast of YouTube. That stream was demonetized about halfway through. I think it was at the jokes that Alex was giving. I looked it over before submitting a request for manual review, because it said, other than the jokes, other than maybe some discussion about the Iraq war, I didn't think there was anything objectionable in that. I asked for a manual review, and they remonetized after manual review. And the only reason I care about this, that would be one stream of 70 that we've done, more than that, 100 and some odd that we've done in a year. I only care about them suppressing that when they demonetize a video stream. You see it in the views, and you see it in the spread. I was just happy that maybe it shows a bit of a turning of the tide at YouTube. Maybe it shows they're a little bit more desperate for the money, or at the very least, people can see that stream now, and YouTube can never take that away. But
no doubt. But
I'm a little concerned about the one with RFK. I'm concerned because I know YouTube now might have more of an issue with anything that is deemed to be medical advice on COVID than AJ. Maybe Alex Jones is not on YouTube's bad boy list as much as it was, but a little concerned. We'll see where it goes.
Yeah, and the thing is, Bobby Kennedy doesn't purport to give medical advice. He gives the legal arguments why people should make their own decisions, and he provides government records and other medical doctors to say here's what their opinions are. And that's pretty much it. But he's been aggressively targeted, and so the Indiana suit is the tip of the spear. Hopefully, the judge takes it seriously, because in my view, an emergency use authorized vaccine is supposed to conform to the Nuremberg Code of 1947, which means it's not supposed to be mandated, period, by anybody, anywhere, anyplace, anytime, until it becomes an FDA-approved vaccine. Then the other thing with this is some of these vaccine mandates are not, and apparently this was true of the Indiana University, one of their subclass groups, are people who have already got COVID. And so according to the available medical literature we have so far, is that if you've already got COVID, you are or even in some cases, more, according to Congressman Thomas Massey and others, may have more immunity than what a vaccine can provide for. And so it's like, why are they not excluding that group? If you've already had COVID, why are you requiring that group? It seems more and more like this is more about government coercion than public health. When you're requiring people who have already got the vaccine, already got the COVID, the disease that you're already immune from, to require them to get a vaccine. So they have a lot of good arguments they've outlined, including the Nuremberg Code of 1947, including the emergency use authorization limitation, including just looking at the math on this. And the math on this still hasn't changed from my debate. We didn't get into the math, but we got into the legal standard with Professor Alan Dershowitz. And he agreed and he's very pro-vaccine in this context. Has even debated Bobby Kennedy on this precise topic as well. But he agreed that in order to compel a vaccine, there needs to be substantial evidence that not getting it presents a severe risk of harm to other people. And it has to be a substantial risk of severe harm. And right now, if the only thing a COVID vaccine does is protect asymptomatic and pre-symptomatic people from causing harm to others, that risk is microscopic at this point, especially as more and more other people have already got vaccinated. So you're talking about an unvaccinated person spreading it to another unvaccinated person only in their pre-symptomatic, asymptomatic stage, especially on a college campus, which is one of the lowest risk populations in the country. So I think it will be if they can mandate this vaccine, even at this stage of emergency use, they can mandate any medical treatment they want, anytime they want, anywhere they want. Your bodily integrity is gone. Informed consent is dead.
I think a lot of people already see that, and a lot of people see the justification for compelling the vaccination in a certain demographic who themselves, again, I don't want to say anything that can be deemed to be scientific statements. Demographics who are at minimal risk of the virus, to compel it there, the argument is that you're doing it there to prevent, like you say, the asymptomatic or pre-symptomatic spread, which might get to the adults. So effectively, you're imposing a medical treatment or a medical intervention on a group at low risk, not for their own benefit, but for the indirect benefit of groups who are at higher risk, who in theory have already gotten or will get the vaccine and should have already protected themselves. So it's this double overlap of protection, but compelling it on a demographic that is not inherently at any meaningful risk by all stats.
I'll put it this way. I believe the evidence that will be alleged in these suits is that the risk of someone in a pre-symptomatic, asymptomatic stage spreading COVID that causes someone else to suffer severe harm or death from getting it is microscopic and minuscule. My guess is less than one, maybe as low as 1 in a million. And if they can force you to take an invasive medical treatment into your body for a 1 in a million risk, well, heck, they can mandate the flu shot. They can mandate anything. They can just start mandating whatever they want, whenever they want, wherever they want. And that's why, at a minimum, this case needs to establish the legal standards that limit the ability. When can they force this? When can they require it? What data and evidence is substantiated? Because ultimately, Dershowitz and I agreed on what the legal standard is. And I believe that the evidence at this point doesn't justify such a coercive compelling of invasive medical treatment.
I mean, that is the bottom line. Is you and Dersh did agree on the substance. It's only a question of applying it to the particular facts at hand, and whether or not you perceive or anyone perceives this virus as being the one that meets the required threshold in order to justify what would otherwise be for the measles. But even for the measles, I mean, yeah, you can't get into kindergarten if you don't have your shots, unless you have some sort of medical exemption. But the idea there,
or in most places, actually, is a good transition. Most places, a religious exemption to protect your First Amendment religious rights as well as your parental rights over governing the well-being of your children. And so that leads to Bobby Kennedy and others bringing suit in the District of Columbia, because the District of Columbia gives us a further script. Like the federal criminal case shows us one thing, Indiana University case shows us another thing. The DC case shows us the final conclusion of all this, for what Bill Gates himself called the final solution. Just might want to add that.
But pause that there. The final solution, the big lie, and COVID deniers or vacciniers. All three of these terms are based in Holocaust terms, and people are using them without fully appreciating that the big lie was an Adolf Hitler propaganda strategy. The final solution, we know what that was. And what was the other one I just said? Oh, Robert,
deniers.
Deniers. They turn Holocaust deniers into climate change deniers, into COVID deniers, into vaccine deniers. Everything has this implicit comparison back to the Holocaust, so they can demonize people with different opinions, as though to have those opinions is to be tantamount, consciously or subconsciously, to denying the Holocaust. It hurts me, but sorry.
Unless you're Bill Gates, and then you say final solution, and you get all excited. The just to see how many times that guy smiles during a video where he's talking about all this. By the way, if people don't believe there's any public warnings about side effects associated with this particular medical treatment that's now being coerced everywhere. Just go back and listen to Kamala Harris during the campaign, listen to Joe Biden during the campaign, listen to Bill Gates describe it where he kept getting smiles as he said, oh, then this can happen, and then this bad thing can happen, and then, man, there's something wrong with that dude. But putting that aside, the genius of the suit being brought by Bobby Kennedy is what happened is the District of Columbia passed a law that is going to allow the school systems to inject your the children that attend those schools with the COVID vaccine without their parents even knowing about it, without any parental consent. But they take it a second step. Speaking of fraudulent documents, the law requires the doctors to forge the vaccine records documents of these kids' school records so the parents don't know what happened, and to send one set of records over to the school and a different set of records to the parents that don't disclose what took place. And in particular, like DC, like most places, recognizes First Amendment rules and has a religious exemption. So all that's required is a good faith basis to acquire that. As well as a medical exemption. What they're doing is they're circumventing religious exemptions and medical exemptions that are actually already in the law as well by doing this, because they're just getting the kid. If you're 11 years old or over, and as one of the DC council members who objected to this said, my 12-year-old can't figure out how to play Fortnite, and I'm going to give him control over his own body for a big decision. I don't think so.
And we've talked about this a couple of times. Ontario has the Youth Health Act, or they call it something along those lines. British Columbia as well, which basically says that the kids can consent to medical treatment, either in the absence of or notwithstanding parental opposition, if they have a doctor's approval. And the court, the doctor, and the kid thinks it's in their best interest. This has been used in transitioning cases, and this has been used now in vaccination situations where they're basically saying, yeah, if the kid wants it and the parents object, the kid can do it. And like I said, one thing I said, I don't care how mature the kid is. It's not like a 12-year-old knows their medical history in the first place to even, maybe they had an allergic reaction to something when they were kids and they just don't know, because 12-year-olds, I don't want to say they're idiots, they're 12-year-olds and they don't know their own history. So it's over the top in terms of what the government is allowing 12-year-old kids to do in the absence of consent, in the face of objection, or in the ignorance of their own parental duties. And it's over the top, but it's what some might feel to be in the government assuming the role of God and the government assuming the role of parents, of everyone. Sorry,
and it's
over. Go ahead.
It's a very well brought suit by Bobby Kennedy, challenging the first and foremost, this is a due process violation over the parents' rights to control their children's own health and well-being. Public school is not supposed to be a replacement or substitute for that. They cite a bunch of U.S. Supreme Court cases on this, and the general principle that the schools are not substitute parents. The schools do not have this authority to act in a godlike manner. But also, Bobby Kennedy's actually been one of the best advocates. In 2000, we passed a religious rights protection law. I forget the exact phraseology, but basically it provided stronger protection when the Supreme Court was busy watering down the First Amendment freedom of religion. It created a statutory protection that expanded that against a wide range of actors, including state governments. And what it pointed out was that you needed to meet strict scrutiny if you're going to burden in any way religious rights. And it's always been recognized your right to religious exemption from coerced medical treatment of your own children. And so in that context, he points out this violates the statute as well. And then other claims as well. It's a very well drafted complaint, well designed complaint, well planned out complaint. And we'll talk about it a little bit more with him on Wednesday. But this is another, now you're in the District of Columbia. So, good luck with those judges. You got to hope you get the right draw. But this is another critical case, because if the government can use access to children through schools or childcare programs or anything else to circumvent parental control over their own children's bodily integrity, then we're in a scary new place.
And I'll say this: I brought up a couple of chats which less eloquently address the problem. The problem is this: a 12-year-old doesn't know the medical history. They're 12 years old. And, people are saying, well, if these restrictions, these court interventions were generally, historically, and legally put in place to prevent the parent from depriving the kid of life-saving treatment as opposed to how it's being used today. And for anybody who says that 12-year-olds are so mature that they can change their gender if they so choose, despite the parental objection, they can take medications. I mean, on the one hand, the obvious argument is, can a 12-year-old get a tattoo if they really want one? Can they start drinking alcohol and smoking if they really want to? And not to equate vaccines to that. The issue is to say, if a 12-year-old is so mature that they should be able to make these decisions themselves, the law already provides for that. I suspect you have the same emancipation laws that we have in Canada. If a minor is so damn mature that they can lead their lives in the absence of their parental guidance, notwithstanding their parents, and on their own, get emancipated by the court, go through the full test to see that you're fully able to be recognized as emancipated, notwithstanding your minorhood status, and then make whatever decision you want. But this is it's like punctual emancipation on political hot topics. Oh, gender issues, you're emancipated for that specific decision, but not for getting a job and learning about the economy. Vaccine, you're politically emancipated, but not for what television shows you watch, not for smoking, not for getting into watch American Pie because it's 16 and over, whatever. It's politicizing literally of infants or children. And we already have laws that respond to this problem that could just be that can be applied to resolve the problem without bypassing, circumventing, and in some places concealing from the parents what is being done to their kids. It's egregious, but my biggest problem is that the media has done a very good job demonizing Robert F. Kennedy Jr. to such a point that people reflexively, like with Alex Jones, think he's an extremist vax denier. Or anti-vaxxer. We're going to get into it more on Wednesday, but it's like people in the chat are probably more wise than the general public.
The MIT did a study, and they assumed that they were going to find that people that were hesitant or skeptical of the COVID vaccines were less educated and lower IQ and more misinformed. They found just the opposite, that if you gave them a COVID test, a COVID vaccine test, they would score the highest. They were the smartest, brightest, most informed. And that's because, this is when I suggested a year ago, this is where they were going. I had tons of people say that I was just being conspiratorial and had been hanging out with Alex too much. Well, here we are, folks, where they're going to such lengths that the schools are demanding that medical professionals lie to parents and forge documents in order to cover up what's taking place while they're busy prosecuting people for presenting alternatives. If you don't agree with the government, you go to prison. If you go along with the government, you need to do forged and fraudulent documents to deceive parents. So it's a deeply disturbing law that hopefully Bobby Kennedy's suit will successfully overturn.
And I've been having a discussion with a friend from the day one. Sure, there's a risk the government's going to overreach and you're going to lose some rights and the government's not going to be reluctant. You're going to be reluctant to give them back. We have gone from 2 weeks to flatten the curve to shutting down businesses, to preventing people from having their own family in their houses, to force social isolation, social distancing, to curfew, to required mask mandates, to compelled vaccination, and now we're in the realm of criminalizing, to some extent, speech. It's not the gambler's paradox. It's just that people have now given up so much. They have to justify their losses to themselves and say, well, it's for the greater good, so I feel good about. And no joke, whenever you go to a casino and you see a big loser, at the very least in Canada, because the casinos are sort of province run, everyone's like, yeah, okay, fine. So I lost $1,000. It goes to the government. And it's going to go help communities. That's the justification for having lost your money. And right now people have lost their freedoms, and the justification is basically the same for the greater good. But for people who said they're going to go too far, they've gone too far, but people cannot recognize it or they cannot admit it anymore because they've lost too much.
Indeed, I'll be looking at filing suits over the next several weeks against, looking at suits against pilots unions, looking at suits for cops in San Francisco, looking at suits for employees at Madison Square Garden, across the country related to these coerced COVID vaccines that don't have the health, medical, or religious exemptions that really it needs to have if it's going to conform to constitutional standards. People are in a rush to do this. But speaking of things that the They think an 11-year-old can change their body forever, including even maybe changing their gender, without even parental consent being involved or parental knowledge being involved. Well, at the same time, they have laws that they're cheering on that prohibit 20-year-olds from even owning a handgun. And that law went up and was challenged at the Fourth Circuit Court of Appeals. And they said at least by the age of 18, you have a Second Amendment right to bear arms in self-defense.
Explain to the stupid Canuck, what was the justification? What was the rationale for setting an age limit on certain types of firearms, but not others?
This was almost all passed in the mid-'60s. It kind of relates to the Rittenhouse motion to dismiss the gun charge in Wisconsin that's pending, which is in the mid-'60s, early '70s. A great fear arose as crime exploded. It couldn't possibly be a whole bunch of programs that were creating these kind of effects. No, that couldn't be it. Instead, it had to be the availability of guns. And so if they could just ban 20-year-olds, 19-year-olds, and 18-year-olds from having guns, then this would provide for a magical reduction in criminal violence with handguns, mostly exploded by gangs at the time in the late 60s, early 70s, when movies like Dirty Harry and Death Wish and the rest became popular. And so now, of course, it didn't. It had no negative effect that anyone could document on guns, which has been part of the problem. They haven't updated the legislative history. And what the Fourth Circuit noted was really it's twofold. One, do 18-year-olds have a Second Amendment right in the first part? And then secondly, if they do, what's the justification for this law currently? And the big one was the first part, because they were trying to argue that only 21-year-olds could have a Second Amendment rights, when generally 18. And I think they made the right decision. They particularly focused on what I believed always should be the focus. The reason for the militia component of the Second Amendment was to make sure your method was, frankly, it was to prevent a standing army. And they admit this, actually, the Fourth Circuit. That's the whole point of it, was to not have a standing army because we didn't trust a standing army. And if you look at Joint Chief of Staff Milley, you understand why we didn't trust a standing army. We were right then, we're right now. But that ship has sailed, unfortunately. But even with that, the idea was that your Second Amendment right to bear arms and of self-defense was to be able to also collectively organize for your self-defense in the form of militia, so that whatever restrictions would be counterproductive to an active militia would be counterproductive to your self-defense rights. So this is, for example, why I believe the Wisconsin law in the Rittenhouse case that the prosecutors claim prohibits a Wisconsin 17-year-old from having having a rifle. Well, I disagree with them about the interpretation of the law. I think the law specifically excludes 16 and 17-year-olds and allows them and authorizes them to have a rifle, because that goes back to the farm culture of Wisconsin, back to the 60s and 70s, where that would be a principal person defending the farm. They were worried about handgun violence in Milwaukee. They were not worried about rifle violence on the farm. But putting that aside of the statutory interpretation, I think constitutionally, our current federal being able to call up the militia, the federal government still has that power. They just don't exercise it. Under the federal law, you are obligated to be called up if you're 17. So they only went to 18 because that was the only thing before them. And they said at least by the time of 18, you have a Second Amendment right, and this handgun restriction does not meet the scrutiny required. They looked at it under both strict and intermediate scrutiny. I think everything should be strict scrutiny, but putting that aside, they're like, under either one, this law under the current circumstances doesn't fit. They can't show any nexus of dramatic reduction of crime by preventing licensed dealers. And then they highlighted this, licensed dealers from selling a gun to an 18, 19, or 20-year-old. Because as almost anyone who studies gun violence knows, 90 to 95% of gun violence that's criminal is committed by people who don't own the gun legally. For obvious reasons. If you're going to go out there and commit a crime, you're not going to have your gun traced back to you. They're not that dumb. And part of the drug trade and the guns trade just goes hand in hand, always has. So it was a great Fourth Circuit ruling. They may try to challenge it up to the U.S. Supreme Court, but I think the U.S. Supreme Court would affirm it if they took it. Clearly, the Second Amendment should apply to at least 18, and in my view, it should go down to 17. Because it should correspond. If the U.S. government has the right to call you up as part of the federal militia, Now, even though the draft currently is at 18, theoretically that militia statute could lower it to 17 constitutionally, then you should have a constitutional right to be able to defend yourself and your community at the age of 17 by the most effective method, which is to be able to bear arms.
But now I just want to make sure that I didn't say something incorrect. Did this case pertain to all firearms or to specific types of firearms?
It pertained to all firearms, but the ban was only on handguns. So that's why they only talk about handguns, is that's the ban that was on it. But it means you have a right to, you have the same right as an 18-year-old as a 22-year-old.
Okay. Interesting. Now, is this going to be a federal impact, or is this a state impact that's going to have impact in other states?
It's constitutional. It was striking, though, so it would apply to everywhere because the Second Amendment applies to the states. That the Heller decision was to the District of Columbia. The subsequent McDonald decision was to the city of Chicago. So it applies to everybody.
All right, and now I want to say something. We are at we just crossed over 3,000 live viewers on Rumble, and it's looking good over there. So that's amazing stuff. Robert, now I guess you mentioned your first movie reference, and we'll get into the second one, which is going to come in the critical race theory case, which is DMAR versus District 65. Now, reading this case, I forget what it was. District 9. What was the movie? I didn't see the movie. I just know what it's about.
The movie's called District 9. Yeah,
District 9. The fact that it's called District 65 as a defendant in this lawsuit throughout the lawsuit is telling. This lawsuit. I read this, and I don't want to use hyperbolic rhetoric. I felt like I was losing my mind reading this lawsuit. What they're teaching in schools, if the allegations in this lawsuit are correct and accurate, is over the top. And I don't know how it has even gotten to the point where this could be acceptable to any, let alone to the many. But I suspect the many just don't know what's going on. And so the first thing to say in this lawsuit is that the plaintiff has to be very courageous to have filed the suit, because I think she's a creative arts teacher and who's filed the suit in her own name, knowing the backlash that she's going to get in this particular environment, but basically going after the schooling system for teaching critical race theory to kids as young as pre-K, reading certain books. I mean, I wish maybe one day I'll learn how to screen share, but I think it'll detract from the overall, just from the discussion. But they're teaching things to pre-K kids, reading a book that basically say whiteness is bad. It was a bad deal to begin with. You effectively shaming people based on race, effectively, and of their own admission, separating everyone by race, identifying them as having the racial aspect being their defining aspect for the purposes of demonizing whiteness, and portraying it as something to be ashamed of, to the point where you have to renounce it effectively. The curriculum's nuts. And the question is, does this violate certain laws? Does this violate certain constitutional rights? I don't understand how, in a country that has civil rights, we know who started the civil rights movement and who was intended to protect, but we can all agree it's intended to protect, I imagine, all civilians and not just some. But how did we get to this point where they are teaching this in schools and it has not been checked at any point until now?
It was a shift. I mean, well, credit to Christopher Rufo and others for highlighting it and bringing it to, and Tucker Carlson, because, Rufo was on a campaign along with others, James Lindsay, who will be a future sidebar guest, on this issue, bringing it to the public attention, the court of public opinion. Then Tucker Carlson promoted it. That got President Trump's attention. And then Chris Wallace had to lie about it in the first debate and pretend it was about something other than it was. What they've masqueraded it as is as teaching about the history of racial discrimination and just having honest history. That's never what it was. It was always about shifting the paradigm from racial equality to racial equity, from race neutrality to race essentialism. It's where the alt-right and alt-left all agree is on racial essentialism. Everything's defined by skin color. I mean, it's particularly the white thing is kind of crazy because, I mean, that's a construct of the last 100 years. It didn't exist 200 years ago. The idea that Italians and Poles and Russians and all are all the same because they have the same pigmentation of skin, preposterous.
And to break it down there, like, this is where I say, like, the whiteness thing makes no sense because of that. I mean, obviously, like all Europeans are white, or except some aren't white. I don't know where they draw that line. But even within the whiteness, if you're gay, I guess you are now within a subsect of the whiteness that is not part of the whiteness. And if you identify as other, you are now no longer within this. If you are hypothetically an Anglo-Quebecer in French Quebec, you might be white, but you might not be part of the whiteness. If you're an Irish Catholic in a Protestant society, you might not be part of the construct is that's the oversimplification of how insidious this notion is that you break it down, there might be like that. The only I mean, you might be left with Bill Gates as the personification of whiteness. Everyone else can find an exception somewhere down the line.
Well,
Sorry.
And what they did here, you're right, is crazy. I mean, first, they're being taught to 3-year-olds and 4-year-olds, but the second thing, and so they're being taught that race is their identity. White, it's a form of blood libel. It's a form of Marxism. Hate people that are a different race than you. Only celebrate the racial identity in you unless you're white, and then feel ashamed about it. Go through a Mao-style cultural revolution struggle session. That's what a lot of these were. Requiring teachers and staff to go on shame walks for being white. Privilege, go on and do privilege speeches for being white. One teacher telling another teacher they're going to take their metaphorical machete and strike them down until they admit and acknowledge the evil of their skin color. This is what was being taught in public schools and being demanded. I mean, this was the person who brought suit is a drama teacher. It's not like they're some right winger. They're just like, I believe in individuality and creativity, and this is bad for the soul.
The thing that I found most shocking was the open stated desire to what was the word they used, to break down the nuclear family. And
yes.
And
that's white. For people that don't know, this is why BLM is obsessed with this. The nuclear family is a white creation. We should go back to some sort of having multiple spouses, not really even having spouses. I mean, the nuclear family itself is inherently evil, and this was being taught in our public schools.
Well, I want to say this is the soft bigotry of low expectations to the idea that a 2-parent household, the nuclear family, is white and not, for the people who say trust the science, and not scientifically and statistically proven to have benefits for the raising of children. For the people saying trust the science to then come out and say we should deconstruct the nuclear family because it's evil, because it's white, other than being absolutely racist as a statement itself, as if other cultures were not brought up on 2-parent households. I'm not even making suppositions of gender. The more cohesive a family, the more beneficial effects on the children is, if not science, at the very least statistics. And for the people saying trust the science, which implies statistics, to say this, it's over the top. But it's also just, it is fundamentally racist through the soft bigotry of low expectations to say that the nuclear family is white. And that should offend everybody. But that's where I sort of lost it when I was reading this lawsuit. Yeah, a drama teacher, sorry, not a creative arts, a drama teacher has to file this suit knowing full well that there were internal emails basically saying castigate and intimidate anybody who comes out against this. And which brought us to the causes of action. I'm just saying, like, what laws does this, other than being offensive and insidious and disgusting, and made me want to pull my kids out of public school if they were there, or have a serious discussion with them? What laws does this break concretely for anybody who says, okay, I hate CRT, but why is it illegal? And how can people protest against this judicially, and through the courts?
Well, 2 different ways. One is that all of our laws are based on race neutrality and race equality. So our laws, our Constitution, and all of our race discrimination laws are almost all entirely opposed to the doctrine of racial equity or racial essentialism or racial identitarianism or racial sectarianism. So our laws say anything that highlights race, that discriminates against race, that uses race to judge people and assess people, and in any way discriminates against them in their treatment by their employer or by the government is wrong, is illegal. And that's why all of CRT is illegal. And they were just getting away with it because they made sure nobody either knew about it, and those who knew about it, they intimidated and not bringing suit about it. And then they lie about what it is when they get in front of them. The problem is guys like Christopher Rufo have been getting the documents from whistleblowers all over the place. Disney was about to teach critical race theory. They need to teach screenwriting is what they need to teach. Instead of just hiring wokesters and you end up with Black Widow is going to lose a ton of money because they decided to have a woke plot combined with woke directors and a woke screenwriters. Not working out, folks. But the same thing with CRT is that this is it's inherently discriminatory, inherently violations of the Constitution of almost every state and of the United States government and of federal and state law. And that's why they brought claims under all of those grounds, because this is deeply offensive. The second component is passing laws that ban this. And of course, it's the never Trump world of David French, et cetera. Little Frenchie who had to quit running because he didn't want to, only get 100 votes for the presidency and have to be embarrassed. Who's out there pretending this is about free speech. This has nothing to do with free speech. This is public schools. So this is what public schools teach is not subject to First Amendment protection. What you do outside of the school is what the student sometimes does is, but not the teacher, because we're paying for that with our tax dollars. That is subject to the determination of the community. But the one thing they can't teach is open racial discrimination and racial prejudice, and that's what critical race theory is. So this is one of the best lawsuits to expose what critical race theory is all about. For anybody out there that has friends or other people saying, "Oh, I just heard it's about opposing racial discrimination," just send them a copy of this suit. Say, okay, would you like to walk on a white shame walk just because of the color of your skin?
Robert, if I may, can I share the version you sent me, which has highlights in it?
Oh, yeah.
Someone remind me. I'm going to share because I pulled it up now. First of all, to answer the question of the comment there, the chat was, in the United States District Court for the Northern District of Illinois Eastern Division, Stacey Demar versus Board of Education, the City of Yada, District 65. Let me just get to the book that they read, because the book was really. I'm not going to find it.
My brother was recently at. We may have him on in the fall because he's writing a book, but the philosophy professor. But he was at his bookstore. Those still exist. They're shrinking, but it was at a bookstore with his daughter, and it's like every other book was some version of critical race theory or some identity politics for kids. I mean, they're doing. That's why they took over the Hollywood as much as they could. They're indoctrinating kids, and a lot of Zoomers believe in a lot of this gibberish. They believe that the mythology. And that's because, unbeknownst to many of us, it's what's been taught in schools now for half a decade.
And I got the section. For example, this is an allegation in the lawsuit, paragraph 126. For example, in 2020-2021, all teachers from pre-K through 5th grade were instructed to read aloud "Not My Idea," a book about whiteness, ordinary terrible things, by Anastasia Higginbotham. I don't know who that person is. Not My Idea teaches, quote, "Racism is a white person's problem and we are all caught up in it," end quote. Not My Idea teaches, quote, "Even people you love may behave in ways that show they think they are the good ones." Interesting hashtag confession through projection. Not My Idea teaches, quote, "In the United States of America, white people have committed outrageous crimes against black people for 400 years. Not My Idea teaches, quote, "White supremacy has been lying to kids for centuries." Not My Idea teaches, quote, "Innocence is overrated." Not My Idea teaches, "Whiteness is a bad deal. It always was." That's one of the things. That's a book they're reading to pre-K. The thing is this. I like to think that I have an open enough mind that I would be outraged by this, but I would have the discussion with my kids. But I can see people not being so open-minded about having their pre-K read this stuff.
Yeah, I mean, I would probably have my kid wear "My teacher's a racist" T-shirt to school, and, cause a lawsuit. But
or show up with the InfoWars mug, although no one would know what the graphic was.
Yeah, probably right. Just keep flashing that whenever the teacher was talking.
God, man, I remember the first time. I never knew what that mug was, Robert, until someone said IW. I was like, and I finally put it together. But I think someone in the chat helped me.
An I and a W.
Okay, let's see. I mean, my issue with this though is that it seems to be literally mainstream streamlining the idea that only white people can be racist, and that when it's racism against white people, it's not racism because racism is, discrimination plus power, something along those lines, where the idea is defining racism as something that cannot affect anybody else except for the people you want to demonize. But this CRT literally seems to be the embodiment of that philosophy, that it's not racist
and
because it's against white.
Polled, a majority of both Black and Latinos Black Americans and Latinos don't support CRT. So the idea that this is, popular within those, it's not. I mean, there's a reason why Trump did better amongst both groups. That this kind of politics is not really popular with anybody outside of a small portion of the professional class left politically. But look at who dominates the legal profession. That's exactly who dominates it.
Let's see here. It says Ian Hall says, LOL, Mr. Barnes, if you want an educational law title compliance person, you let me know. I happen to know a very bored retired educator bulldog who advocates against educational administrators and will be happy to eviscerate them. Again, she is bored. I forgot what I was just about to say. It had to do with, it's the soft bigotry stuff. If I am, I don't want to go towards my specific identity, nor will I. If I am any identity that is caught up in this CRT, I'm offended at the idea that someone says a two-parent household is white. And I'm offended that anyone says math, logic, punctuality. Anything that is on the list of white privilege is itself racism, because it implies that anyone who's not white is not capable of or does not respect these values. And it basically, it's demeaning and racist on its face, and not against the white people, but it cloaks it in such a way that, everyone else is just incapable of these things, which every culture on earth pretty much has valued. And math itself, as far as I know, was not a white person's construct in the first place. But I will say it again and I'll end it on this. It's soft bigotry of low expectations, and everyone, especially those who are being protected by this, should be offended by this.
Yep. Yeah, the only ancestry I identify as my favorite one in the census, which they run into a lot. Census takers get confused in parts of Tennessee, Kentucky, and some other parts where they say, are you English? Are you French? Are you German? They're like, no, I'm American. And then they ask them, no, we mean what? No, American. And that's still my favorite ancestry. And it's the ancestry that we all belong to. And that does not teach racism in any form.
Go ahead.
Oh,
no, it'll be the segue, but I've had this argument. I've had this discussion. In as much as history has a tainted, did I say America? In as much as America has a tainted history, has blemishes on its history, so does Canada. When it comes to the outrageous acts that whites have committed in the 400 years of American history, it was America that freed the slaves globally, and not just on American soil, despite international pressure to not do so. It was, in as much as Americans participated in the Atlantic slave trade, they were the ones that rose up against it and fought against it and freed the slaves, despite opposition from every other power overseas, in Europe and elsewhere in the world. And so it's like Trudeau goes around celebrating the tragedies and ignoring the successes. One has to be intellectually honest in the manner in which they deal with these things, and to focus on that as the core element of CRT, to ignore the greatness of America and that it has done despite its blemishes, is intellectually and historically dishonest. Now, with that said, Robert, sorry, what were you going to say?
Oh, no, I was just figuring out a transition. That another thing that is not racist is the AOK sign that you can find with Barack Obama, you can find with Beyonce, you can find with Jay-Z.
The LeBron James. I mean, anybody who has ever signaled for a three-pointer. Did I just do it?
Yeah, scuba divers use this. You can find it on your emojis on Twitter or other places, Facebook. So however, the person playing Gru, the character from Despicable Me, the actor at the Universal Park in Florida,
my goodness,
did this with some kids, got fired, and now Universal has been sued by the kids' parents because their kids have been traumatized because they think the AOK sign is a secret white power sign. So it goes in the rankings of ludicrous and frivolous lawsuits that should be tossed. I established several years ago for Cassandra Fairbanks against Emma Roller that saying that this is a white power sign is libel and defamation actionable in court. In that particular case, that's another story. They'll go to the That's Another Story version of Viva Barnes Law.locals.com. Future blog coming.
But this is the thing now. This is the dynamic with the OK symbol, which makes it it's the push and pull. It started off as a 4chan gag. Okay, everyone should appreciate this. They said, we're going to push the idea. And I remember I was not vocal. I was not into this stuff at the time, but I was following it. They said, we're going to push the idea that the OK symbol is white power, because the idea is that I'm not doing it so that no one makes a meme out of it. But
and there's an actual two-handed gesture that is actual white power. And they thought, I bet we can fool a bunch of the media into believing that just the AOK sign is really the two gestures into one.
Well,
they're that dumb and that lazy. Turns out they are.
Well, but the graphic was quite beautiful, Robert, because it did show that the three fingers pointing up were the W, and the circle with your hands and your wrist was the P, and that meant white power. That was where it came from. So 4chan starts the gag. It's either the ACLU or the other one. Which one picked up on it and flagged it as a hate sentence?
Well, actually, both the ACLU and ADL initially recognized that it was clear that was a gag. So there's some people who claim what happened was 4chan created a fake ADL, and they created a fake ADL meme that said it had the ADL doing it. And so people think ADL did so. Actually, as I cited in my lawsuit for Cassandra Fairbanks, because she's half Puerto Rican, and she had done this at the White House. And they're like, oh, secret, this Emma Roller, pretend journalist, they claimed it was a white power sign when clearly it was not a white power sign. And so consequently, that's what's led to it. But ADL has acknowledged, as far as I know, that is not. This is just the AOK sign, like everybody recognized. Again, it's still an emoji on big tech.
Well, and I forget which one it was, but it was on one of their websites. Then they corrected it. But then this is the issue: is once they make it, and once they try to qualify it as a hate symbol, even after they retract it, it becomes the gag, and people do it to be edgy, knowing now that the gag was picked up on by a mainstream whatever, even if it was corrected afterwards. And then that's how you create the what's the word? The baggage for the symbol in the first place, so that you get people doing it to be edgy instead of, and then it takes on a life of its own. But let's see. No, I won't bring up that chat. But it's yeah, that was it. It's hilarious.
It's a frivolous suit. It's just a frivolous suit. Again, a federal court has already established identifying that as a white power gesture is libel, because not only it's false, you should know it's false. And so for these parents to bring such a ludicrous claim just shows you how deep the rabbit hole in the echo chamber is on parts of the left. Because, I remember talking to a GQ journalist who thought, that Kyle Rittenhouse using it somehow meant something. I was like, don't tell me you're that stupid. I had like a 2-minute lecture of him. I just went off. He was, to his credit, he corrected himself on that one. But it's just A-OK. It's been A-OK forever. And I refuse to allow a 4chan hoax to redefine a symbol. And just because parts of the media left want to do so doesn't make it so. Next, remember the other 4chan hoax was they were going to try to convince people that milk was secretly racist. So that,
and again, I think that people actually picked up on that in a serious manner. I remember it. Geez, I think this was back in Reddit days, but I'm not sure. Without spreading misinformation on that. What else do we have on the menu? Okay.
Oh, well, speaking of sort of lawless actions, another federal court has found that President Biden's version of DACA, which he's continued to extend from Obama, the Dreamers Act, is unconstitutional. Of course, that was frankly apparent from day one. But for a range of reasons, the U.S. Supreme Court managed to divert the issue. So that's why that litigation sort of died out. Somebody brought new litigation for Biden's continued implementation and administration of DACA. And now the court didn't have the guts to reverse the prior DACA awards of what went on. And that was always going to be the case. Due process was going to kick in. And then you were going to have, the power of the presidency versus the due process rights of the individuals who had reasonable expectations and what they thought the president gave them. But he said in the going forward, there can be no more DACA. The DACA is dead moving forward. So the people that have already sort of grandfathered in are continually protected, but there's no more new DACA. So if that was a goal or objective of the Biden administration, it is already, like many of his other immigration provisions, DOA, and other racial discrimination provisions, DOA. He's lost almost every racial discrimination, every case he had where he was trying to racially discriminate in how money was distributed for COVID, for farms, for bars, for restaurants, has lost. Even the one that was issued by that friend of mine in Tennessee is guaranteed to get reversed. So so it's across, but this is another big loss for the Biden administration.
But now explain the impact, because look, I know what DACA means, deferred. Oh, geez, Louise, I just totally forgot the acronym. tell us the acronym, but also the ultimate outcome is that they're no longer going to be taking applications.
Right.
But didn't the judgment itself stay its own application?
Only as to those who already had it. So it's dead on. Now they've appealed it already, the Biden administration. But I think this was probably a mistake of the Biden administration, because it was clear the U.S. Supreme Court was going to find DACA unconstitutional. It just found a way, procedural means, to avoid the issue. And so now this comes up cleaner and neater. It's the Biden administration trying to continue to expand it and extend it into perpetuity. And I believe that this decision by the district court will be affirmed ultimately, maybe by the Supreme Court, probably by the Court of Appeals. U.S. Supreme Court probably won't even take the case if the appeals court affirms the district court. So I think it should be the final nail in the coffin of DACA going forward. The people who already benefited from it, the courts are probably never going to take remedial action as to that. So that in that sense, doing an illegal action, if you vest people's expectations in it, you can get away with it. But you can only get away with it until a court finally steps in. And it looks like a court is now finally stepping in so that it doesn't continue unabated.
Okay, and it's deferred action for childhood arrivals.
Yeah.
But so everyone who's already submitted, fine, they're grandfathered in, grandpersoned in. What impact is it going to have on future applicants who will now no longer be able to submit their application? Where do they lie? Like, they're going to be illegal.
They got to go back through the regular lawful citizenship process, which is what should have been all along. If people have problems with the immigration laws, change the laws. Don't have the president create his own law. And
this is why, I mean, I've heard many lawful immigrants say we don't like this because everybody who wants to come in. Some go through a tedious, costly, lengthy process, and others, I don't want to say cut the line because it sounds glib, but others effectively get in through whatever means, and they say, I'm here now. Now I want to effectively not have to go through what everyone else who came here had to go through, which I suspect is part of the motivation as to why we're seeing sort of politics ruins everything, a double-edged application of tolerance when it comes to Cuban immigrants versus don't cross the ocean to come here, but if you cross, you'll get better treatment because of political reasons.
Yeah, Cubans vote the wrong way for the Biden administration. That's where they don't want any Cubans coming. They got enough Cubans in the last election, so they won't be cheering that. But the hypocrisy was fascinating. I mean, what I'd often said was Democrats would have a totally different position. They would be hard borders people if the people coming over they thought would vote against them. If it was Uganda, that's why I say it's never even a racial issue. If it's, say, Nigerian Christians have a legitimate asylum claim due to various forms of religious oppression there, you're not going to see the Biden administration sending any planes for them. Instead, they'll be sending the military to drop off illegal immigrants all across the country, which is what they're currently doing. Catch and release and secret release in communities that people don't even know it's happening. So it's going to be another potential legal issue down the road. The cities may be able to bring suit, like the Texas sheriffs who are currently suing Biden for non-enforcement of immigration laws. And I think that will continue. And it's a pattern. Speaking of lawless Biden actions, the Biden and the CDC have been sued for their mask mandate this week in federal court. In a very good suit that just lays out all the same grounds as before, which is first and foremost that the CDC, just like they have no power to order evictions, they have no power to issue mask mandates on public transit everywhere in the entire country. That their authority is limited to going in and fumigating something. They're the equivalent thereof. It was not to dictate a form of medical Sharia law, which is what they are effectively imposing. And so that challenge is pending on. Also, they violated APA. They didn't go through the Administrative Procedures Act. They didn't go through notice and comment. It's not a statute that was passed by the legislature. It exceeds federal jurisdiction in the first place. So all of those challenges statutorily and constitutionally are also present. And it should win for the same reason that in Florida, challenges to the mask mandate in other contexts have already won. There, where the state of Florida brought suit over concerning the cruise industry, and where the CDC has lost every one of these suits on the evictions. The Supreme Court, Justice Kavanaugh, just gave him. He said, "Yeah, it's probably illegal, but it's almost over, so I'm not going to do anything about it." Reality is, the Supreme Court didn't want to be the mass eviction court, so they were going to allow this to expire in July, at the end of July. But this mask mandate should be struck down, and hopefully it will be. But it's a well-drafted, well-crafted suit filed in Florida.
Okay, now, and also, I know we've mentioned it before. Just explain what the term mandate means. People throw this term around. When does something become a what does a mandate mean? And when does guidance become a mandate? Or when does a recommendation become a legal mandate?
So, what's interesting is airlines were already mandating it, but now they've found a way you can now challenge the mandate because airlines are enforcing it because it's now a federal mandate, which is that any form of public transit of any kind, you're required by the CDC, just like you're required as a landlord not to evict, and your local courts are required not to enforce any eviction proceeding. In the same way, the CDC has ordered all of everybody that's involved in public transport. They cannot allow someone to be in that public transport without a mask. I mean, that's what, if you're in an Uber, you're still required to wear a mask, which makes no sense these days. But so that's now there's also grounds that this couldn't be justified on medical basis. Anyway, CDC didn't try to justify it, by the way, when it passed the rule on medical basis. That's why it circumvented the notice and comment period. And so because I don't think there's any basis at this stage to require, especially with all the data that so far, places that mandated masks versus places that didn't. We have a year's worth of data from all around the world. There's no difference whatsoever in the growth of COVID. There's no evidence that the mask worked. And so I think that so that's an additional reason why. But I'm just against medical Sharia law as a matter of principle.
People are going to challenge you on the mask effectiveness because I look it up. There's studies that say it would have been X. They reduce it by Y. People are going to disagree with you on that. So I'll push back only to say that people are going to disagree with you, Robert, and there's going to be studies that are going to disagree with you.
Sure. And but again, if the CDC felt confident in it, they would have gone through the notice and comment period. They didn't. So that means the CDC doesn't feel confident that they would win in a court of law on whether or not it's medically necessary.
Apparently, I can't take 3 shots of whiskey. That would be irresponsible. What I will do is I might top off my glass with a little La Chaufferie gin. Someone just said that the CDC just won against Florida in appeals. I don't know if if I misread that, but
I haven't seen that if that's the case.
But Robert, there was one thing we have to talk about. Let me just see where I just saw the word Maricopa County. I don't know what's going on.
Yeah.
I've fallen out of the loop, but I'm watching Rakeda. I'm watching Nate on Twitter. Some people are saying it's nothing. Jim Sciutto, I don't know who he is. I just pick a fight with him whenever I see him on Twitter because he drives me crazy. But so what's the latest on the audits? What's relevant? What's irrelevant? What's the meaning? What's not the meaning? Set the people straight, and everyone can call you biased and whatever after your assessment. But inform the people.
Currently, there's audits in Arizona. There's an audit in part of Fulton County. There's calls for audits in all of Georgia, all of Wisconsin, and all of Pennsylvania. There's an audit likely moving forward in Pennsylvania by the state Senate.
What's the scope of the audit? What does the audit include? What does it exclude?
Really, everything that goes to the counting and canvassing of ballots that should have occurred the first time, in my view. So it's looking at did only constitutionally qualified people vote? Did they only vote by a constitutionally qualified method? And doing the count and canvass in a constitutionally qualified manner according to the original state legislative rules. So it's double checking the machines, double checking the paper ballots, double checking the voter registration rolls, double checking all of the procedures whereby people were considered legal voters, cast a ballot, and how that ballot was counted and canvassed. And so according to state legislative rules rather than outside of state legislative rules. And so, for example, in the Maricopa County, a preliminary report from the audit is that there were a lot of ballots that were cast that have questions concerning them, either because of who cast the ballots or because of something about the ballots themselves. And so now where there has been, I'm all in favor of audits because they increase transparency, public confidence in the electoral process. They identify flaws in the process. They expose those flaws for remedial action, legislative or executive. They keep the public informed throughout the entire process. And they can lead to legislative reforms and can lead to political change down the road. Where there's been some confusion is there's some people out there who think that the effect of the audit can be a decertification of presidential electors and that can lead to the change in the presidency. There's people who think that it can change who's in the Senate or in the House, and they're mistaken.
Okay, so and before we get there, because I know what Nick Rakeda said about it, but first things first. Apparently, from the audit, there. Oh, sorry. Your Apple ID phone. I just got a pop-up from Apple on my screen. I don't know if anybody saw that. Apparently, the audit has revealed some anomalies, but the extent and the meaning of these anomalies have yet to be assessed, I guess. Duplicated ballots, the totals not matching the certified totals. Explain what that means to ignoramuses like myself, and whether or not it's relevant at this stage or what it could mean at a later stage.
So what they've preliminarily identified, and again, it's not final, not conclusive, not verified at this stage, their preliminary identification is that there are people who cast ballots were not registered at the time they cast ballots. That there are people whose ballots were cast, but then later were recognized that they shouldn't have been able to cast ballots. And then there are a bunch of ballots that themselves don't appear to have been lawfully cast ballots based on the nature of the ballot.
Do we know numbers on this?
As well as some other issues about whether the machines caught things in a timely manner. Tucker Carlson went into detail about that in Georgia. Now, the hand recount likely resolved that problem. There's some questions about that. But the point of this, and that's where I've been emphasizing to people, the point of this is not changing the presidential election outcome. The point of this is to figure out what happened and how we can make sure it doesn't happen again if there were problems, and how to correct them and remedy them and increase public confidence in the elections. The context of, sorry, go ahead.
Oh, no, I was going to say, do we know the number? Because I saw this is going back to
varies. Different ballots in different categories. The one that a lot of people are talking about, 74,000 ballots in question, is to one category. Then there's 16,000 in another category, so on and so forth. If people are wondering, are there more ballots in question than the margin of victory in Arizona, the answer is yes.
Okay, and now this brings us to the second question. First of all, Jim Scudo, someone is saying, the big lies that people are believing now, that the audit has shown anything relevant. I thought, that is an oversimplification to the point of being fake news, and that's what they do. It's not going to change anything, and this is something you have mentioned. We've discussed it, but this is your knowledge, not mine. From day one, from before we were not even allowed to discuss this on YouTube, you said there is no changing the outcome with respect to the presidential election. Now, is that the same as relates to senators? Because I understand there's a legal distinction.
Yeah, there is, but it's rarely consequential. So for people to understand, basically you have a limited time frame whereby you can set aside the results of the presidential election. The same is true, though it's a different timetable with some different rules depending on the state, for the Senate and the House. But in both contexts, once it's done, it's done. And the only remedy after that is impeachment. There is no decertification of electors. There's no callbacks of electors, recall of electors. That ship has sailed. And to give people an example, this often comes up in the political context. So, for example, various of our constitutional amendments were certified by the archivist, whoever the Congress gave. At different times, Congress gave different people the authority, but ultimately it went to the archivist, who's the head of the Library of Congress. And if that archivist said this amendment has met the constitutional standard to now be part of the Constitution, it was immediately declared thereafter. That was a legally binding decision that cannot be contested or challenged. People try to challenge this in the context of a bunch of different amendments, but particularly the 16th Amendment, where they documented that there was good evidence to believe that the archivist had made a mistake, that it had not met the constitutional requirements for passage. The courts made clear, we're not getting near that with a 100-foot pole, because then we have issues with the 13th, the 14th, and the 15th, and we need it to be final at some point. And we're just going to say, once the archivist makes a declaration, it's final. It was my argument with a Hollywood director as to one of the big loopholes in the Constitution is that technically the archivist could probably declare himself king and disband Congress because he has the final power to declare what's in the Constitution by saying what amendments have passed. So theoretically, I remember that this Hollywood director believed some crazy stuff. He was like, oh, no, that's way too crazy. That can't be true. I was like, that's one of the things that is true, not all the crazy stuff you believe. But he was sitting there on his bed while he's doing it. So it was a crazy scene. But well, you had like people coming in. So because of that, they don't. That's one example. Another example is Congress or state legislatures will pass a bill, and later there'll be arguments that there was fraud in the passage of the bill, that there was misleading, that the House didn't count the vote right. And the courts have been clear, we're not touching that. If the Speaker of the House, whoever the designated official is, says that bill is passed, end of story. We don't look past it. We don't look beyond it. And so the same is true for federal elections for the most part. There's certain very limited circumstances in which House members or senators, there can be an issue, but that is generally determined by the House and Senate itself. same issue. And generally, expulsion standards are required, and generally those expulsion standards are usually 2/3 of the relevant House or Senate. And I also don't encourage people who think it's a good idea to open up that can of worms to just start recalling people on grounds that they didn't really get elected. You think about who has the power and how likely that's going to be used for you or against you down the road. So I don't encourage that line of thought anyway, but there is no legal authority. Anybody telling you recall, whatever, that's purely a symbolic vote that they're talking about. There's no constitutional authority for that to have any constitutional consequence.
All right, I'm just bringing this up. We don't hypothesize on these types of things.
Yeah, I have no idea. I mean, I assume. I mean, dude was old, really old. Now there was a funny meme where Death was trying to pick different people out, and he's like, and the Death character was like, "Dadgum, I was trying to get Kissinger." So I did like that meme, but that's because I dislike Kissinger.
All right, now we are cutting it close on time. Good judgments coming out of Spain.
Yes, the lockdowns were unconstitutional and violated the Charter of Rights, which is what every European court should recognize. And even though people pointed out it's of modest consequence, also they didn't pass the emergency legislation by using the legislative branch. This was all around the world. They not only violated core constitutional rights, in my view, they circumvented our entire the entire world's methods of having balance of power between the executive and legislative branches. And finally, the courts, long after the fact, sadly, but it's better now than never because this will prevent it from happening ideally in the future.
Yeah, but or will it? I mean, I'm thinking of the Netherlands, the Dutch courts, basically saying, declaring it unlawful as well. It went to appeal. While it was pending appeal, the court goes and jams through the law to make it legal. Are we not dealing with a very similar situation right now? Or the next time around, they're going to say, well, now it's a super duper emergency, so that court case or that decision no longer applies. Are they going to appeal it? And what is the precedential value of that decision on the grand scheme of things?
It's that if they're going to do that level in Spain, if they're going to do that level of invasion of people's liberties, they have to have the legislative branch involved at a minimum. Okay. And so that will be a check on the process in the future because the legislative branch wouldn't have gone along with the degree of what went on and all that. That's why they circumvented them in the first place. Otherwise, they would have had them on board. And so it's useful in that regard. There was another good European decision that said employers can have non-discriminatory policies that basically the question was, could certain religious groups in Europe impose their religious beliefs on private employers? And this included traditional Sharia law about what women could wear. And the European court said, no, that you cannot impose that. Your right of religious expression is not a right of dictating to an employer compromise with that if they have a non-discriminatory policy that doesn't allow for that to be displayed. So that I thought was good. Now, on the flip side, state of Texas ordered a woman to not allow her divorce to go through state courts in Texas, but ordered her to a Sharia court instead to decide her divorce, which this goes back to the Scientology discussion we had before about the same issue. What can be required is arbitration. And this is a problem with arbitration. I've never liked arbitration. It's a way of privatizing our legal system in ways that almost always will work against underdogs and ordinary people for institutional actors. This is another example of it. But a pernicious one, because if they're going to say, if you get married as a Muslim, you have to always be governed by Sharia law and by other Muslim enforcers of Sharia law in the United States, that, in my view, violates a lot of core constitutional rights, including the right to have a state court determine your legal rights in the context of a divorce, because often under Sharia law, many women don't have the rights that are protected under the United States.
Well, I would say this should not, in anyone's mind, ring as being specific to Islam. I think it'll surprise a lot of people to have any religious courts.
Religious group.
Yeah, any religious courts in a state system where you have laws, you have rights of citizens, where historically religion has treated sexes differently, and to some objection that has spawned some opposition. So the idea of even having religious courts in any state or country, because we have them in Canada as well, will probably surprise many, but this is not specific to any one religion. The ultimate irony, in Quebec, I think it was Bill C-60, and I forget the name of the bill, but they were outlawing in offers for provincial employees any demonstrable face covering religious symbol. It wasn't specific to Islam, although people thought it was specifically targeting Islam. no face coverings, no hijabs, no turbans. It also said no overt crosses, kippas, or Jewish stars. But they were trying to prohibit face coverings. And then, 2 years later, they are mandating face coverings. And then this is just the beautiful irony of having no logic to your laws, where what is outlawed one day becomes mandatory the next. But I think the idea that a lot of people would be surprised to appreciate that their states, their countries have religious courts, and the state courts, the constitutional laws of the country, deferring to those could be objectionable to some, all the more so under certain circumstances.
No doubt about it. I mean, what's interesting is that feminists and other people are not talking at all about this case.
Well,
so it's like, this has a particular implication for the interest. There's a big difference between how Sharia law and Sharia law enforcers treat women's rights compared to how in this case, Texan courts treat women's rights in the context of divorce, as just one illustration. The same analogy applies in the Scientology context, where, alleged victims of sexual assault should have a state court and a state jury determine that, not a Scientology court determine that, when they are accusing the many higher ranking people within Scientology of being complicit and culpable. That is pending potentially before the U.S. Supreme Court. So it's the same, but it's also why corporations shouldn't be allowed to force small consumers, ordinary people, into arbitration that almost universally favors institutional actors at the expense of ordinary people, and is very rarely a reliable process. They're usually low-level judges cashing in who are not the most ethical or most independent. I'm yet to meet an arbitrator with an IQ over 60. Mm-hmm. So the legal IQ over 60. So, I'm not a fan of in general, and religion courts being compelled against people's will, definitely not in favor of. But this case, it was Texas Court of Appeals that where this is going to be pending in front of.
It's surprising. I'm in line with you on that. Religion is voluntary, and the minute somebody says I no longer want to be subjected to religious courts, that should be the end of it. And I should full disclaimer for the world: I didn't mean to bring up the previous chat. I meant to bring up this one. So I think the other one was a little more edgy, to put it mildly. Okay, Robert.
Two brief updates. One on the Tim Pool Subverse lawsuit. You did a good description for people who had a lot of questions about how corporate structures work and all of that. One other addendum. We get a lot of our feedback and ideas from the message board at vivabarneslaw.locals.com. A lot of the cases, some of the cases I didn't even know about. Those members, where basically everybody that's on that board is above average. But advice to Tim Pool. Tim, in the future, take advice from your comment section, because what I didn't know, but people on the board pointed out, was when we discussed the suit last week, they're like, we recognize those people. We warned them 8 months ago not to have them and to get rid of them because they're clearly crazy, kooky, and likely criminals. So, Tim, next time, listen to the board.
Two things. First of all, this is the collective knowledge of the internet. There were two stories that came out this week of a mother who posted a picture of her 3-year-old. And people picked up on the way that the flash reflected differently in both eyes, that something was wrong with one of the eyes. And sure enough, the kid had a tumor behind the eye. They found it, solved it, problem solved. The collective knowledge of the internet is flabbergasting. Someone gave me a hard time for using that word. It's beautiful. I went back to that stream. Everyone's like, yeah, we saw that stream 8 months ago with the two of them. They were sketchy AF, which I now means as FUCK. They were sketchy. The top comment, or one of the top comments, was, don't go into business with this guy. He's going to screw you. There's something fundamentally unethical about this guy. And then, sure enough, after I put my video out, one of the responses was, this comment aged well. Yeah, it's amazing. The collective knowledge of the internet, it might hurt to read sometimes, but it's genuinely and generally quite good. The one thing I forgot to mention in my video today, answering some questions, was the unanimous shareholders agreement, which may be immaterial to this discussion because I don't think they had one, but unanimous shareholders agreement can confer to the shareholders obligations that are otherwise conferred to the directors. That's why you sign one. But parentheses closed. Yeah. A lot of people giving Tim Pool a hard time because he didn't listen to what the collective were saying at the time. And it's amazing, actually. Hindsight is 2020. Kierkegaard, life can only be understood backwards, but must be lived forwards. Beautiful example.
Speaking of good news, Britney Spears looks like she's going to ultimately win completely her conservatorship just by going public and exposing that, and having that then exposed to the whole world, because people decided to display it regardless, despite the courts trying to keep it secret, which I don't like. There's a federal court trying to go after Lynn Wood for sharing what happened at the sanctions hearing. And while I've been very critical of Lynn Wood, this is not a thing I am critical of him up for. These public proceedings should be publicly available, and courts need to quit hiding it from the world. It's disgraceful and, in my view, unconstitutional. Here's always the problem. When you challenge those rules, guess who gets to decide whether the court's own rules are unconstitutional? The same courts. So it's a problem. But to Britney Spears' credit, because of it, she's being allowed to hire her own lawyer. What's fascinating is all the roaches scattered as soon as the lights went on. So as soon as she did her thing, all of a sudden the next week, everybody who was coming in for the grift and was on the grift was like, we got to go now. But we see the door. We'll be right back. They were running for the door, running to get out of there.
And this is not a pot shot at anybody, so do not interpret it that way. A lot of people were running the defense that Courtney has her own lawyer. It was just court appointed. That's not your own lawyer. So
no.
Court appointed is fine. That's by the court. Britney, the argument was, is entitled to her own lawyer, but because she's under a conservatorship, she can't make her own decisions. So the court makes her decision for her. That court appointed lawyer was never Britney's lawyer. We'll see let's see who she hires. Robert, did you get a call, if I may pry?
No, I mean, she's hiring a big corporate law firm. That's
and not to start rumors. That was a joke.
I don't hire a big Hollywood firm, but it won't matter. As soon as she went public, everybody started running. It means that everybody who knows conservatorships know that's about to get wrapped up and close it down. So she's going to finally get her life back just by being brave enough to take a stand in court publicly and openly, and by a lot of other people sharing that information around the world. The lawyers got the message real fast. All the grifters got the message real fast. Time to get out of Dodge before the limelight comes.
The only problem is Madonna's going to say that she's going to claim the W. It was all because of Madonna.
Yeah, exactly. So we have
whoever said I'm drunk, by the way, I have an iron leg or a wooden leg. So no, the one shot, I have a measurement glass. I am very meticulous when it comes to things. Sorry, Robert,
so
go ahead.
A few questions from the locals board from Havana Allen. If Trump became speaker, could they impeach Biden and Harris and make him president? Yes, legally, yes. May not be the most practical or probable political outcome, but yes, that could in fact happen.
Can I? A lot of people are saying it, but am I wrong in thinking that the former president of the United States does not want to run for the Senate? I mean, is that not?
He can actually be made speaker without being elected to the House. This idea is coming from Steve Bannon, and I can guess why Bannon's really promoting it. Bannon thinks it would be a great turnout mechanism for Republicans in 2022 for the House if they said, elect us and give us the majority of the House, and we'll make Donald Trump our speaker. So it's a political maneuver, not a probable maneuver. Trump himself was like, he laughed. He's like, I don't think so. But it's but legally possible, but mostly it's probably just politics and not very unlikely to actually occur.
But that's actually fascinating. So the Speaker of the House does not have to be an elected official, can be an absolute outside appointed official.
To my knowledge, because my understanding is the Speaker of the House, whoever the House says is Speaker of the House, whoever majority of the House says. And so I think the House's own rules get to determine that. Is my understanding. And again, the courts don't second guess whatever the House does. Very rarely. From Pseudo Snark, talking about, how is it that like the Army can't edit its YouTube page, but the President of the United States and the press secretary can talk about editing Facebook pages? It's a good question. What it is when it is a state actor, then doing it, then they can't punish free speech. Now, the way Biden has got around that on his own YouTube page is rather than banning specific comments, he's asked YouTube to not allow any comments because it's clear that he doesn't think a lot of those comments will be helpful to him.
No comments and no thumbs up or thumbs down identification last I checked, because they'll call it a brigade, they'll call it a movement to just make it look bad, or it's just people speaking their minds, because I leave comments open, I leave thumbs up visible. And it is what it is, even with the occasional brigade, which I've never had. It might be that people are thumbs downing and giving negative comments because it's rubbish. It might be, or it might just be.
Yeah. Sometimes it can be either one. But let people make their own judgment and decision from it. But But yeah, so that's why it all comes down to, is it a state actor? Are they doing it in their state capacity? The reason why Trump was not allowed to ban people on his Twitter page is because the court concluded he was doing so as a state actor, even though it was his personal account. From Tim, Arizona, will the Bidens ever get prosecuted? Well, whenever Kamala decides she really wants to be president, that's when you'll start hearing stories about maybe Joe and Hunter are in some trouble. But until then, they have about as much a chance of getting prosecuted as the Clintons do. So no matter what they do, just never seems to happen.
And I just want everyone to remember this moment, 2 hours and 9 minutes, give or take. Robert, I think this is going to prove to be prophetic because I had never thought of it. And it is exactly the way political opportunism works. The second it becomes politically unpopular or politically opportune, people will change, individuals will change. And if Biden does not go out for other reasons so that Kamala can take over, fantastic point. And I saw a meme today. I don't remember where I saw it. I wish I could remember. It says what Biden got for a painting and what Don Jr. got for a painting. One said, 500,000. The other one was him behind bars, because it is the unequal application of the law and unequal application of politics. But yeah, that's interesting.
And there's tons of fantastic memes of Hunter Biden's artwork that people can look up. People are doing some great stuff with that. From Kirk here, I answered the question about congressional election audit impact. And the last question was from Cat Speaks in the top 5. Why did it take so long for the DACA ruling to come down? Explain that as well. Basically, they're on parallel paths, and this is about Biden's DACA extension.
All right. Now, I was hoping Winston would come down for tonight, but apparently my wife is not getting my text messages. So there will be no Winston. There will be no, noise kids coming over the shoulder. Another amazing stream. Robert, in the beginning of the stream, someone said they need optimism and they need encouragement going forward, because seeing some of the stuff that's going on, some people are not encouraged or optimistic. Lead us into the new week with something good.
Sure. So one case we didn't mention was, some religious students stood up at the University of Iowa against an attempt to discriminate against them, and they won. Just like those 18-year-olds that said I should have a right to self-defense, and they won. And Britney Spears stood up against 13 years of exploitation, and she's about to win. And on Wednesday, we're going to talk about someone who has been fighting the odds, and his father did before him, in a wide range of contexts and circumstances. Robert Kennedy Jr., who's optimistic no matter the circumstances. It's a guy getting smeared and shamed around the world. Could have taken the easy path, chose the hard path instead. And the DC suit is a testament to the credibility and authenticity of his actions. And the various successes that we've seen are testament to why that is the case. It's always the case. The greatest trick the devil ever pulled is convincing people he did not exist. The greatest trick the system can pull is convincing people they cannot resist. If you avoid the futility of perception of your own actions and your own power, you'll discover that, like Britney Spears, you can occasionally finally be free.
All right, I'm going to say this. I'm going to end on this one. A recently found Van Gogh just sold for $250,000. Hunter sells for $500,000. Must be a glitch in the matrix. Here's one thing. This will be my optimism for the next week, is that once you see things outside of the matrix, it looks depressing and it looks discouraging, and sometimes it will be. But life finds a way. The human species has found a way. And by and large, when you share the ideas, the good ones will rise to the top and the bad ones will sink. But it's a marathon. It's not a sprint. And so I don't know what leg we're in, because we don't know how long this marathon is, but it's a marathon. So
one addendum, this book behind me is Robert F. Kennedy Sr., Bobby Kennedy's father's book from his campaign trail to a newer world in 1968 for his assassination. And this one is Fixing the System by Adrian Kosminski, A History of Populism Across the World and Across Time. And I will be at the live chat after party at vivabarneslaw.locals.com, pinned at the top of the board in just a few minutes.
All right. And with that said, I hear noise. I hear someone coming. I don't know if they have a dog, people.
We do not have dogs.
They do not. Just come say hi, and then we're going to call it night. Okay. We got one. We're live to 10,000 people right now. Hi.
Oh.
All right. With that said, people, come say hi.
Hi.
Okay. Hi. Everyone, enjoy the rest of the week. Everyone, thank you for being in the comment section. Thank you for the support. Wednesday is going to be a good one, and then next Sunday is going to be another great one. So enjoy the week.
Next Sunday will be Saturday.
Oh, I'm sorry, Robert. You're right. Next Sunday will be Saturday. People, spread the word. Saturday Night Live with two lawyers. All right. Have a good night, everyone.